Pardon, make a mention by item 28.
Page wise. Page wise. Let us go serious.
Page 1, 1 to 5.
Item 5, my lords. Mr. Pallet is not well. It, my lords.
How did you know to?
Any day after 1 week, your lordship.
So we comment in Chachari Kuchum. Yes, next.
Page 2, 6 to 16.
My lord, I have item number 6.
Huh.
I prefer next week.
On 6th one. The amount has not been paid.
Yes, my lord.
Amount has been paid or
Paid.
not paid?
Paid.
Receipt पे कहीं fail करना है?
Receipt has been filed.
कितने fail कर? तो जेड़ा सुनो तो.
Yes.
Order has to be passed. This cannot be. अब अपेक्षा करो. This will reach. Next. 7 to 16. You are mentioning the amount.
Minus item number 7. But I have some medical emergency. I have an appointment with Dr. Malas. Kindly next week.
You have a. You have medical emergency.
Yes, LLC. I will do that matter, LLC.
On 4/2/2026, Division Barik on behalf of Division Barik for the petitioner.
Yes, LLC.
The order dated 4/2/26 was passed after hearing the learned counsel for the petitioner at length. Paragraph 3 of the said order is reproduced herein. Today, the matter being in the list is mentioned by the learned counsel for the petitioner, and adjournment is on the ground of medical emergency of the learned counsel for the petitioner. Stop. Accordingly, the matters to grant further opportunity to the petitioner listed in the week commencing 6/4/2026.
Malas, interim order was there.
Sorry?
Interim order was there.
Which order, sir? Which order you are referring?
Unless,
Which order interim order was granted?
Malas, order dated 4/2/2026.
Which paragraph?
Sorry, Malas. Pardon.
Sorry, minus paragraph. There is
Pardon,
no paragraph. It starts at 1 and ends at 5. The copy of this order shall be forwarded to the learned court, Learned Judge Family Court Balasore in CRP extension number 300 of 2023, along with the order dated 4/2/2026, to be kept on the records of the said CRP execution number 300 of 2020. Yes, next.
8 to 16.
Next.
17 to 25.
You said 17.
28.
26 to 30.
28, my lord.
Yes.
In this case, counter not filed by the government, my lord. Counter is required, matter relating to disengagement from service.
Yes.
28,
Mr. Linka. Counter not filed. Counter file korantu.
Yes, sir.
That's date kar diyo to.
letter 26.
28.
Or 28 chari week.
26 one.
Yes, what do you want, sir?
On behalf of J.K. Pada, he is out of station. Kindly taken over after 2 weeks.
26 counter not filed, Mr. Lenka. No, he is mentioning. I am not. I mean, as you know, I do not. I am not asking the order. But since it is mentioned counter not filed, I am asking you. Date करो तो 26 से.
उत्करण से 20
10 years old matter, Mr. Bhanti. 10 years old matter. केपे कहले? 20 week. Yes. Item 26 20 week. Yes, next.
page 5 35 to 40
Item 32.
Yes, 32.
At 32, I am for the respondent. Your Lordship, I sought last occasion, I sought time to take instruction if there is any possibility of settlement. But there is a possibility of settlement. But if your Lordship, I have taken consent from my learned senior. My learned friend is there on behalf of my learned senior. But if your Lordship considers my submission and refers this matter to mediation, but there is a possibility of settlement.
What is the order? You see, you are seeking mediation. In what order you are seeking mediation? For payment of
Yes. No,
payment, I am not
no, no.
referring.
They have challenged the order, rejecting their application for declaration that the marriage between the parties to be dissolved. Madam. Dissolution of marriage ପାଇଁ ସେମାନେ challenge କରିକି ଆସିଥିଲେ.
So 13th, dissolution means 13 hours. 13th,
Special Marriage Act section.
Special Marriage Act
That
single
is a
bench.
single bench. Matter has been referred to single.
32, the matter being in the list is mentioned by the learned counsel for the parties. Mr. Appavanada, sir? Sachi Ranjan Behra. Mr. Sachi Ranjan Behra, on behalf of J. Pradhan for the petitioner and Mr. Subhendu Kaur for the opposite party.
Yes.
The petitioner husband in the marriage is before this court challenging the order passed by the learned judge, family court, court. Learned judge, the learned district judge Nuapada in a MAT case number 8/112/10 of 2012-14. Order जो लिख लें by judgment. By judgment order लिख लें. Judgment. Judgment dated 5/3/2024 passed by the so and so. Hello. The said MAT case was filed by the petitioner husband in the marriage. Seeking declaratory reliefs under the provisions of the under section 27 of the Special Marriage Act. Inter alia, to declare the marriage certificate to be non-exist in the eye of law and not binding on the petitioner therein. हाँ सेंटेंस टा कौन लिख रहे? This one, so one. It's a good ticket. It is submitted by the learned counsel file for the parties that the matter may be referred to mediation. Stop. Accordingly, it is directed. The case records and connected papers relevant shall be forwarded to the mediation center. Stop. Court annexed mediation center. The learned counsel for the parties shall appear before the coordinator arbitration mediation center. Aji ke tarikh ho? 9 tarikh, 10 tarikh. नहीं अजी मार्च 10 yes. केबे जाई परिबे आपण?
Any date, your Lordship.
17/3/2026. On the same date, a date shall be the coordinator shall fix a date for placing the matter before the mediator. The date of appearance of the parties before the learned mediator shall be fixed, and it shall be intimated to the parties as well as the learned counsel for the parties. List in the week commencing 4 May 2026 by the next date, mediation report / interim mediation report shall be placed before this court. Grateful.
Sorted mediation.
अरे कूड़ा short date. Short date कूड़ा है. After mediation takes lot of time. At least my experience sitting in judicial side is, I think that mediation is impossible. So my perception now has become that in matrimonial matters, because on questions of law, without having any point, the matters are argued for 2 hours. How the mediator will handle it? Must understand he has to have a persuasive, he has to be at his persuasive best. And both of you agree and the parties to agree. Upon report actually, the longer date is for the report. Upon jodi Raji mediation then you should say clearly today here, so then give some latitude to the parties as well as the mediator to, discuss and deliberate, and hopefully it will be, they will arrive at a solution. Please further observe that the learned counsel for the parties shall make all efforts to arrive at a settlement between the parties acceptable to both. Yes, next.
Grateful.
That's item number 38.
Yes,
Sign for the petitioner malice, I may be permitted to withdraw.
you file your
Memo, sir.
your name, sir?
Malice, G. Das, Gaurav Das.
Gaurav, yes, you are there on record. Yes.
Item 1,
Item 39.
man.
Item
Only ghost title page maybe. I have filed on
Subilan what actually, I'm so sorry. Kuda question to item 1.
39 मतलब
39 में कौन है फिर?
post title page टा add हो मतलब. I have filed on January 15.
এটা তাহলে অর্ডার সে আসছে সেটা এটা তো আপনার নোটিসে আসছে আপন চাহুଛନ୍ତି এটা করে অর্ডার সেট নাহাନ୍ତି না ସେ অর্ডারটা কি
I am applying for a husband party.
so consolidated cost title সেটা আলাও କରିବା
ନା ମତେ ଆମେ ସର୍ଭ କରୁନାହାନ୍ତି କନସୋଲିଡେଟେଡ୍ କଷ୍ଟ ଟାଇଟଲ along with consolidated petition along with all annexure.
କିଛି ଦେଇନାହାନ୍ତି
ମୁଁ ଦେବି ଏଟା notice ରେ ବି ଯାଇଛି
your name sir ମହାନ୍ତ
ମହନ୍ତ.
so kindly take your seat se mention କରୁଛନ୍ତି item 39 লিখিবে the matter being in the list is mentioned by the learned counsel Mr. Kamalakanta Mahanto. Appearance likhiye Kamalakanta Mahanto for the petitioner, Ashok Bera for the opposite party. Referring to the office note indicated in the cause list, it is submitted by the learned counsel for the petitioner that he is filing the consolidated cost title. He has filed, which is on record. The copy of the consolidated cost title along with copy of the petition as well as other records shall be submitted, shall be provided to the learned counsel for the opposite party within 3 working days. Or
Today I will sir.
During course of the day. The matter shall be listed in the week commencing 13/4.
Yes, obliged.
17 ଡେଟ୍ ଅଛି court will
Correct. Transfer application maintainable no. Whatever little I should read and understand, there is no provision to transfer at the will of the sweet will of the parties.
permitted to my lord correct 2-4 ହେଇଯାଇଛି
Right?
TRPC 2-4 ହେଇଯାଇଛି coach title page ରେ first page ରେ 2-4 ହେଇଯାଇଛି 2-5 ହେବ
ଆପଣ ପୁରା consolidated file କରୁଛନ୍ତି
ହଁ
ସେଟା ବି ଭୁଲ ଫିଲ୍ କରିଦେଲେ
ଟିକେ ଭୁଲ ହେଇଯାଇଛି
ସେମିତି କରନ୍ତୁନି ଆପଣ ତ ପ୍ରିଲିମିନାରୀ କ୍ୱାର୍ଟର ଫାଇନାଲ ଖେଳିବେ ବୋଲି ବାହାରିଲେଣି
permitted to
ଆଉଥରେ ଟାଇପ କରି ଫାଇଲ କରନ୍ତୁ My order will sound very, unclear. ଆପଣ consolidated ଟା ଆଉଥରେ correction କରି file କରିଦେବେ.
ଆଜ୍ଞା
It is submitted by the learned counsel for the ଉପରୁ first ଲେଖନ୍ତୁ. Change କର. It is submitted by the learned counsel for the petitioner that inadvertent typographical error has created the consolidated cost title. ତା ପରେ ଲେଖିବେ. ଏଇଟା ଲେଖିଲା ପରେ ତାପରେ ଲେଖିବେ. It is submitted by ଏଇ order ଟା ଯାହା ଅଛି ସେୟା ରହିବ. It is submitted by the learned counsel for the petitioner that he may be permitted to correct the typographical error that has scraped into the consolidated cost title. So if the prayer is allowed, the learned counsel is permitted to correct the typographical error that has scraped into the cost title, consolidated cost title. File done dash. Date ଟା ଆପଣ ଦେଖିବାକୁ ପଡିବ, ସେ କହିପାରିବେ. File done ଏତେ. The said corrections shall bear the initials of the learned counsel for the petitioner as well as shall be countersigned by the courtmaster. ତାପରେ ଲେଖିବେ କପି ଯୋଉଟା ସର୍ଭ କରି ହେବ ତାପରେ ଲେଖିବେ. Yes.
15 file.
Yes, next.
Item 1. This may be disposed of.
Mr. Karunakara Jenna for the petitioner. No one is present for the OUAT. So Misra is nowadays not usually appearing, not in VCRs. You take your seat, I'll dictate the order. The matter has been listed for this court. The matter has been listed today under the heading. लिखिदेवे. The learned counsel for the petitioners files memo, which states thus: the memo shall be taken on record, scan copy be updated. The writ application was filed in the year 2010, Paragon, and was presented before this court on 28/6/2010. Notices were issued on 20/7/2010. In view of the memo filed, the petition staff is posted. Yes, next.
Item 2.
Is this service matter, Your Lordship? The matter counter has been filed and 1 week time may be permitted to file the rejoinder, Your Lordship.
After that's come for referral to mediation.
Any possibility? Possibility of mediation?
Service matter, Your Lordship, reading first week. With regard to reproduction, Your Lordship.
Your name, sir?
Niranjan Naik. I am for the petitioner, Your Lordship.
I have forgotten your name or confused.
Niranjan Naik.
Correct. But I thought you were somebody else. So I for the petitioner. Mr. D.N. Lenka, AGA for the opposite parties. 1, 2, and 3. 4 and 5. None. Notice जाइतला?
Yes, notice जाइतला.
Notice.
Counter file ହେଇଛି, government counter file କରିଛି 1, 2,
4, 5, 4, 5. ଯୋଉମାନେ appear କରୁନାହାନ୍ତି, obviously government ତ ଅଛନ୍ତି, ଆପଣ ମୁଁ ପଚାରିବି ଯେ appear କରୁଛନ୍ତି କି ନାହିଁ. The matter has been listed under the heading so and so, so and so. It is submitted by the learned counsel for the petitioner that is matter though pending since 2012. It would not be suitable for as involves adjudication of service benefit, na declaration, na kon?
Service benefits.
Adjudication of service benefits claimed by the petitioner.
No, sorry.
Recruitment, Your Lordship. With regard to
He
recruitment.
has to challenge the appointment of opposite party number 4 as inclusive education volunteer.
Sure. कौन लिखिए? As it involves, as the petitioner challenges selection of OP number 4 as
Inclusive education
education volunteer
is fine.
in Ichanagar Primary School. OP number 4 को केबे नोटिस ହେଇଥିଲା Mr. Nayak?
In the court, the copy was served. In the court, copy was served. They-
को ऑर्डर रे कोर्ट कॉपी सॉफ्ट कोन था आप तो कौन कोर्ट में जज ओले गले ताकू
No, 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 Your Lordship. In the presence, in his copy was served. Only on 13/10, Your Lordship. Last
1310
13/10/2025.
1310 को मसी आपण तो 14 वर्ष ହେଲା
13/10/2025, Your Lordship.
1320
In his presence, copy was served.
Then
13/10/2025. No, 10/10/2025, Your Lordship. I may be little bad. 10/10/2025.
टेन टेन पच्चीस ऑर्डर
last order is 12.
तो भल पण 14 इयर्स पर आपण भी निजे ट्रैक रखुनांती को नोटिस हला कि नहीं कोथरे नोटिस हला 7/4 नोटिस इशू होई चाहिए को
Yes.
अच्छा
Issue of the law before.
Yes, sir. Notice be sufficient is.
आपण रिक्विजिट केबे फाइल कले
In fact, I have not filed the requisites. I sought the copy in the court, Your Lordship.
अरे ता ना तो फिर किछि तो गोटे कहबे की कथा आपण कहउचंती आपण जाकू देले सी किए को दिन देले कागजटा काई एवरीथिंग हैज टू बी आई मीन टोल्ड थ्रेडबेयर
Yes, sir.
Private party.
I will take a fresh notice.
सर आपण टिके देखि दिले तांदा आपण रजिस्टर्ड पोस्ट विथ एडी 45 टका देकी फाइल कले 7/4/25 रे नोटिस इशू हैला 16/4/25 रे 7/4 रे ऑर्डर हैला आपण 16/4 रे नोटिस इशू हैला पोस्टल ट्रैकिंग रिपोर्ट आसिला 8/5/25 रे प्रॉब्लम हैला जे एडी आसिनी कोन ताको ट्रैक करनांती हो कोन फाइल करचंदी नले स्टेट का मिस्टर लेंका यू आर आल्सो फाइलिंग का रिक्विजिट्स ना कोन सर को जन फाइल करनांती अब की फाइल कला ताले जज तो केबे भी न के फाइल करथिबे
For private party. Channel must have.
ताले नोटिस केमती वाला की देला नोटिस और सीट ऑर्डर देखो सीट देखे जदि भी और नाउ इट इज अवेलेबल फॉर यू कैन वाच रीड इट व्हाट इज द ऑफिस नोट केबे नो फाइल किन के कौन को जाए गले पर it is submitted that according to the matter shall be listed in the regular course or assignment could I am the assigned bench
Yes, Your Lordship.
or since this bench is the assigned since the subject matter of the writ application is in the determination of this bench the matter is taken up to be considered on merits. From perusal of the order sheets, it is apparent that by order dated 7/4/2025, order number 6 ताको देखिए बोलता है एक टाइप करते हैं. Order number 6 सेटा 7/4/25 notices were issued by the coordinate bench through registered post with AD or by registered post with AD. office note dated 15/4/2025 indicates that notice in the admission matter अपन देखिए लिख परियो ହେଲା issue to OP number 4 कोड कर देबे RPAD CPS जहाँ लिखछन्ती RPAD माने registered post with 30 fixing returnable date to 6/5/2025 for appearance and show cause though the AD has though the AD आछि कि नै आपण देखंतु फेरे सेटा भी मते करिया पड़े
Item delivery.
AD postal tracking report has this limitation. Why the people who made it AD returnable, they are intelligent because that's a physical copy. You know that it has been served. In one matrimonial matter, when you ask the postal department if item delivered, then who received it? They say we do not know. Sambalpur matter, we have to say that because they are the parties, they appeared, they contested. The wife said that I have not received. She files affidavit. We asked the postal department. They say we cannot say who has received. We can say that it is delivered.
On order dated 12/5/2025, it has reflected that received showing service of an extra copy of the WPC on such as Mr. KK Jana, Law Counsel for opposite partner 4.
से के जने के मु सेटा ते आपण भाबी कि मु एक्चुअली ये करनी
Is appearing for opposite partner 4.
आपण सीबी के जने
No, my name is Niranjan Naik, N Naik, and opposite the appearing for KK Jana.
ठीक है वकालतनामाटा चेक करନ୍ତୁ मिस्टर बारिक केके जनाका वकालतनामाटा चेक करନ୍ତୁ सेटा पाइजो यो मते दियंतु ब्रीफ आपणकर निहाती ए सब जिंस रजिस्ट्री रे नोटिंग दवा कथा जे की को दिन वकालतनामा फाइल कले ताको ना हो अंतर्जामी भुया OP4 को ना कोन
Yes, Mantaj.
Thereafter, Mr. KK Jena has appeared and has filed wakalatnama. Today, when the matter is taken up, Mr. Jena is not present. Stop. Registry shall intimate the next date of listing to Mr. Jena. केबे आसले हम
After 2 weeks.
2012 मैटर देखंतु लिस्ट इन द वीक कमेंसिंग 6/4/2026 तो बुबु
एक्स्ट्रा कॉपी दे थल
Extra copy.
एंड नॉट रिसीव कर पालो
It an active court.
You are Mr. Jena?
नो
সেটা 39 কজ টাইটেল ঠিক আছে হ্যাঁ কজ টাইটেল ঠিক আছে
ठीक अछि जेना तो आपण क्लेम तथापि भाबुतील सेला सेन करेक्ट ठीक तथापि ताकू
करेक्ट আছে
ताको आउथरे करेक्ट करंतु कि करेक्शन बटन चालू किस
ମୁଁ
दे
ଦେଖିନ ମୋଟା କରିନଥିଲି କରେକ୍ଟ
ଠିକ ଅଛି।
ତ ଦେଖି ନାହିଁ
अरे साडू माने रजिस्टर आसिला ना सार करछन आपण एटा करछन रजिस्ट्री कर देले
एट द टाइम ऑफ फाइलिंग करेक्ट करथिले मो ऑफिस कॉपीटा करनथिले
कारण थरे फाइल होला परे विदाउट नथिंग कैन बी नो इंटरपोलेशन कैन बी कैरिड आउट इन एनी रिटन डॉक्यूमेंट प्लीडिंग्स
Item 3,
The appellant has filed the enhancement of the compensation amount. But the level
मेडिसिन ही परिबनी
medicine is government officer के राजी में नहीं enhancement.
साहब कहबे प्रेम कुमार कहबे सर कोंतु कोन मेडिसिन कहबे
if you want to
Very upon instruction niyantu. He has a point. 1 rupee why because there's a difficulty. Because they may not agree. Why we will agree for they usually say that, but this is an area where government can do. So let me what I'm thinking, let me tell this. It's not part of my order, of course, my perception also. We had worked out on this because court asked us that you work out. You have to have a general policy. That where, how much and where you can have it is there, already there. Justice Indrajit Mohanty, when he was there, so he asked. So there you have to take a lead role. Maybe you have to inform the London Advocate General. But you have to explain what are the benefits of agreeing for a settlement.
Mr.
Nirmal Chandra Mohanty for the appellate. Mr. Prem Kumar Mohanty for the opposite party. Mr. Mohanty, you have not. Now the problem would be: have you implemented the requisitioning authority who pays the money? Because as it seems, I don't know. I'm just asking you.
No, because the matter will refer to the.
The problem is that if you implement the land acquisition collector, he has nothing to. He doesn't pay. You must understand.
Government has to pay.
Anyone. He may be government, railway, or central government, corporation. The land for whom the authority for whom the land is acquired, they pay. Now, investment, who will be asked to negotiate? Who has acquired? This land has acquired for whom?
Or construction widening of road from Domanachak to Subhas Enclave.
So who did this?
Government acquired and
government is not a. You have to say that it is GA department, municipal, Bhubaneswar Municipal Corporation, R&B department. It cannot be in the vacuum.
BDA.
So you have to make the BDA party who pays the money. और लिख ले, appearance लिख ले. It is submitted by the learned counsel for the appellant that if the opposite party will agree, then the matter can be sent for mediation. The learned apparently the requisitioning authority on whose behalf the land was acquired, for whom the land was acquired, that is Bhubaneswar Development Authority, has not been made a party. Implement करो तो दरको. On oral prayer on behalf of the learned counsel for the appellate, the Bhubaneswar Development Authority is implemented as respondent number 2. There is a direct decision of Supreme Court, Constitution, that without, in absence of the requisitioning authority who pays the money, this cannot be done. आपण एनाउन्समेंट मध्ये पार्टी करनथिले. That's the problem. Only. Accordingly, the name the Bhubaneswar Development Authority shall be implemented as R2. Requisites for issuance of notice to newly added OP number R2 shall be filed within 7 working days.
Yes.
Within 7 working days. Represented through secretary of
Secretary.
And you are too experienced to do that. It is submitted by the learned additional standing counsel that he shall obtain instruction from the R1 regarding mediation. Because he is the statutory authority under the Land Acquisition Act who acquires it.
Yes.
He is not giving anything. You have to give him, he will disperse it. There are already decisions of this court also. Justice K.R. Mahapatra's judgment, then I have followed Supreme Court and Justice Mahapatra's judgment that whether the requisitioning authority for whom the land is acquired is to be made a party or not.
Because ultimately they have to pay the amount.
And correct. And as you, since you have said the setting, that is in the interest of the land loser. Because once you do not make them a party, this plea is carried up to Supreme Court that we are not heard. So for a normal person whose land has been acquired, can he sustain the litigation? First phase, referral, then High Court appeal, law, then Supreme Court. So you should get an adjudication which will stand on its leg. Whatever is the quantum of enhancement or whatever, that's a different thing. But this basic flaw in not hearing the other side, no court can overcome. And ultimately the person gets, he thinks that I will not get it. list in the week commencing notice up to the register. Quebec kari 24 24 bana time diyo dusre notice nebe or file ta dele se the impression of party shall bear the impression of party indicating the name and address in the cost title shall bear the endorsement of the learned counsel for the petitioner and shall be countersigned by the court master. Yes, next.
Item 4. May I please your lordship?
Mediation ହେଇପାରିବ?
Mediation, I am ready, but OPG not present.
ଆପଣ ନେକ୍ସଟ ଡେଟରେ ଯୋଉ ଲିଷ୍ଟ କରୁଛନ୍ତି ମେଡିଏସନ ପାଇଁ କୋଉ ଦିନ ଗୋଟେ କରିଥିଲେ ନା ସବୁଦିନ ଆସିପାରିବ ଏନି ଡେ କ୍ୟାନ୍ ବି ଲିଷ୍ଟେଡ ଏମିତି କିଛି ନାହିଁ the difficult part is that for mediation the appearance of the party is the basic first essential ingredient. We'll wait. Take your seat, I'll dictate the order. You are Mr. Singh.
Raghunath Singh.
Mr. Raghunath Singh for the petitioner. Opposite party none. Mr. Mahanti, what you can do, just after the order is uploaded, you download that order and keep it in your file.
No.
You can indicate that BD has been included as a party so that it becomes easier for you also.
No.
Because every time you have to stand up that because you don't have any instruction. Whether BDA pays or not, that's why you are only you will disburse the amount. Yes.
You corrected in it also.
Yes. Pursuant to, I heard that actually. I was not thinking in that line, but when I heard BDA, when I realized that he has pursuant to order dated so and so. Item 4. Opposite party none. Though the matter is pending since 2022, none appears for the opposite party. Stop. The matter is listed today under the heading for referral to the so and so the purida caption ta likhiwe. Para. The petitioner wife is before this court challenging the order dated 7/12/2021 passed by the Learned Judge Family Court Balasore in IA number 65 of 2021 arising out of CP number 275 of 2021. Include order ta apna petitioner ka paina
Annexure 7. Annexure 7 is the
stop kar full stop.
page 15.
The said IA was filed under Section 24 of the Hindu Marriage Act 1955 seeking pendentolite maintenance of rupees 20,000 for the wife in the marriage and litigation expenses fixed at 50,000. The Learned Judge Family Court had rejected the prayer of grant of pendentolite maintenance. The present status of the CP? Any idea?
Pardon me.
Bartaman CP ର status କଣ? Pending ଅଛି.
Is it pending? CP ta pending.
Submitted by the Learned Counsel for the petitioner that the CP is still pending adjudication before the Learned Judge Family Court. So and so. Balasore. The matter shall be listed again under the same heading. In the kebe anibe? Kebe anile habo?
April, 15th April.
Okay, in the week commencing 13 April habo ta? 13 April 2026. The next date of listing shall be intimated to the Learned Counsel for opposite party by the registry. Yes, next.
13th April.
Week commencing 3rd April. it becomes easier to, in case of any kind of unforeseen, yes, next.
Item 6.
MS S. Rana for the
Yes, ma'am.
petitioner.
Yes.
Other side Nanti.
I have already informed. Surjakanda.
सूर्यकांत दास की एसोसिएट थे ना ना कोई ना जानना थी
Suryakanda sir.
आगे
Suryakanda sir.
साल को क्वेश्चन थी
नहीं सांग नहीं सांग associate.
एसोसिएट को ना कौन
Sir ଅଛନ୍ତି ବାହାରଟା.
Oh, Mr. Suryakanta Das for the opposite party. It is submitted by the Learned Counsel for the petitioner that in terms of the order dated so and so, ଆପଣ ସେଇଟା ରିସିପ୍ଟ ଟାକୁ ଫାଇଲ କରିନାହାନ୍ତି କି?
मतलब registry find ହେଇନି କିନ୍ତୁ
ମାନେ କେମିତି ସେମାନେ କେମିତି ନୋଟ ଦେବେ? ଆପଣ କପିଟା ରିଟର୍ନ କରିବେ ସେଟା ରେଜିଷ୍ଟ୍ରିରେ ଫାଇଲ କରିବେ because that arises out of a office note following a high court order, court's order.
in the course of day have
Correct. କୋଉ ଅର୍ଡରରେ ଆପଣଙ୍କ 1000 ଟଙ୍କା ହେଇଥିଲା ସେଟା ପଚାରୁଛି. Pursuant to the order dated, in terms of the order dated 6/1/2026, rupees 1000 has been paid to the Learned Counsel for the opposite party on ତାରିଖଟା ଦେଖନ୍ତୁ
27/1/26.
27/1/26, 27/1/2026. Stuff. Inadvertently, the memo has not been filed in the registry, which shall be filed during the course of the day. Upon filing of the receipt, upon filing of the memo indicating payment of rupees 1000, which have been received by the Learned Counsel for the opposite party. Counsel Paichandi, behalf of the opposite party. The scanned copy be the memo shall be taken on record. Scanned copy be updated. So, और केबे चाहुछंती लिस्ट इन द वीक कमेंसिंग
2 weeks after मतलब I needed.
yes
6/4.
list in the matter will be listed for information in the week commencing 6/4.
Oh bless.
Item 8.
None appears for the petitioner to grant further opportunity. List in the week commencing 6/4. Yes, next.
Item 9.
Yes, please.
May I please, Your Lordship?
Yes.
Your Lordship, in this
You are Miss Jajodia.
No, Your Lordship, I am Miss S. Senapati.
I'm so sorry. S. Senapati.
Yes, Your Lordship.
You are not Saraswati, or you are also Saraswati.
I am Shweta Senapati.
Shweta. Saraswati is already there.
Sir,
You know her.
no, Your Lordship.
You must know all your namesakes who are Saraswati or Shweta, Shivani. That way. Nowadays there is no more 1, 2, 3, 4. I think one name went up to 6. Justice P.C. Rack used to, say that dictate those or that order. So and so 6 articles on behalf of so and so 1. So yes, Senapati.
Yes, Your Lordship. Your Lordship, I am appearing for the petitioner. In this instant matter, the opposite party has filed a divorce petition under Section 13 in Family Court, Rayagada. Lordship.
Yes.
However, Your Lordship, the petitioner of this instant matter has been diagnosed with multiple health ailment, amongst which there is this ailment called lupus. Your Lordship, in this particular health condition, what happens is the immunity system of our own body starts attacking the healthy cells of the particular person. So, Your Lordship, her immunity system is extremely weak. After the divorce proceedings commenced and they separated, the petitioner shifted to her maternal place.
And they are relatively at the advanced age to seek divorce.
Yes, Your Lordship.
So, what is this? She has appeared before the.
She has appeared before. She hasn't filed any objection.
Take
Yes,
it.
Your Lordship.
This is item 9. You take your seat, I'll dictate down. Ms. Shweta Senapati for the petitioner. Opposite party blank. The petitioner wife in the marriage is before this court seeking transfer of the matrimonial proceeding CP number dash pending with CP number 73 of 2025 pending before the Learned Judge Family Court Rayagada to the Learned Judge Family Court Bhubaneswar. The said CP before the Learned Judge Family Court Rayagada has been initiated by the husband in the opposite party, husband in the marriage. Under section 13(1), 1A and 1B. 13(1), actually Roman 1, small I, IA, the college. Though incorrect, IA and IB. Of the Hindu Marriage Act, 13 into bracket 1, then IA into bracket and IB into bracket. Seeking a resolution of marriage solemnized between the parties. So has the marriage taken any political overtones? Because his name is Congress. No political overtones. At times the name has a consequence also. Yes. I tried to think that whether it means some words or something, but then I could not, myself I could not understand what can be the name of, because doctor, Congress, minister are names in Odisha.
Yes, yes, Your
And,
Lordship.
I mean, throughout India also, you have read Tahsildar Singh, that famous husband.
Yes, Your Lordship. We have another client of ours whose name is Congress Jana.
So then your chamber has taken for political overtone. Persons having name Congress are approaching you. Yes. Is submitted by the Learned Counsel for the petitioner referring to the medical reports annexed to the petition that she has developed lupus and arthritis. This is a very critical, actually, it's a difficult stage. Is getting treated at the Department of Rheumatology in SU Medical College. The petitioner is getting this, not petitioner. She stays with her parents at home.
Yes, Your
She
Lordship.
stays with her parents at Bhubaneswar. Issue notice along with this order. Requisites for issuance of notice by speed post and speed post with registration and proof of delivery. Be filed within 7 working days. List up to mention. Returnable date be fixed to, aji kete 10 tarikh ko. Returnable date be fixed to PC 3/20/24. The matter shall be listed in the week commencing 13/4/2024. यहाँ पर लिखिए आइए फाइल करी ना आपण.
No, Your Lordship. But Your Lordship, if I could pray that during the pendency, if any,
You file the IA today.
today I will file the IA, Your Lordship.
So it will be taken up
You-
passed over, or you can, or tomorrow, or when do you want?
If it will be listed, we can get the IA filed today.
The matter shall be listed tomorrow for orders. ତାପରେ ଲିଖିବେ ଆଜି ଡେ ଆଫ୍ଟର କରିଦିଅନ୍ତୁ ଡେ ଆଫ୍ଟର ତାହେଲେ ଆପଣଙ୍କୁ ସୁବିଧା ହବ ଲିଷ୍ଟ କରିବା ଠିକ listed on 12/3/2026 yes yes next
Much obliged, Your Lordship.
yes please
Item 10,
Mr. Pramod Kumar Mishra for the petition
May I please, my lord,
yes please
the petitioner and opposite parties, the wife and husband, madam. The petitioner has filed one case for maintenance that is pending before the learned judge, Family Court, Kotak.
when did she file
She filed, my lord,
date sir any idea
2/7/25.
whenever you are filing any document like petition before the court it should contain a date, place, signature of parties. Otherwise, if you simply file a typed out document which is a plaint before a court, I don't know. In fact, the stamp report, I think it's not permissible. That is my understanding of practice. I suppose file a plaint here without anything, no signature, nothing, no date. Strictly speaking, certified copy. But okay, certified copy is not available, but at least it should be a true copy. Photocopy, true photocopy. ଆପଣ 109/2025 ଆପଣଙ୍କ ନା କିଛି ଦସ୍ତଖତ ଅଛି ନା ତାରିଖ ଅଛି
I have mentioned in date chart, my lord, that was filed on
ଡେଟ୍ ଚାର୍ଟ ଯୋଉଟା ଡକୁମେଣ୍ଟଟା କଣ ଡେଟ୍ ଚାର୍ଟରେ ଇମ୍ପ୍ରୁଭ ହେଇଯିବ
ସେଇଟା
must understand that
date, filing date, madam. Filing date 2/7/2025.
କ୍ଲେମ୍ କରିକି 125 ରେ କେବେ ଫାଇଲ କଲେ
2/7/25.
2025
Opposite party,
CP କେବେ ଫାଇଲ ହେଲା
madam, CP ଫାଇଲ ହେଲା 13/10/2025. Sir, opposite party.
I'm dictating the order. Take your seat. Our learned counsel for the petitioner wife is before this court. Seeking transfer of the CP number 275/25. Pending before the learned judge, Family Court, Jagatsinghpur. To be transferred to the court of the learned judge, Family Court, Kotak. Jagatsinghpur କୋଉଠି ଯାଉଛନ୍ତି
ନାଇଁ ଜଗତସିଂହପୁର ଆସିବ
କଟକ ଆସିବ ତ କଟକ The CP was filed under Section 9 of the Hindu Marriage Act by the opposite party husband in the marriage seeking restitution of conjugal rights. It is submitted that the petitioner wife had filed a CRP number, criminal proceeding number 109/2025 on 2/7/2025 in the before the learned judge, Family Court, Kotak. ଆପଣ କୋଉଠି ଫାଇଲ କରିଛନ୍ତି under section 144 na 125
No, 1 for BNSS.
under section 144 of BNSS 2023 seeking monthly maintenance. Notice ହେଲା କେବେ
Notice appear kale 10/9/25.
notice କେବେ ହେଲା ତାର ଉତ୍ତର ହବ appear କଲେ 10/9/25 Pursuant to the notices issued by the learned judge, Family Court, Kotak, the opposite party husband appeared before in the said CRP on 13/10/2025.
No, 10/9/25.
Sorry.
10/9/25.
I'm so sorry. 10/9/25. डेट गुड़ा ठीक लिखछन
Obviously.
डेट अपन देखि परिबे 10/9/25 issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days.
File.
5 working days. Returnable date be fixed to 6 April 2026. List in the week commencing 13 April 2026.
Oblige.
ଆପଣ ଆଇଏ ଫାଇଲ କରିନାହାନ୍ତି ଆପଣ ବି
No.
ଆଜି କଣ ହେଲା କି ଆଇଏ ଫାଇଲ କରିନାହାନ୍ତି
IF.
ମାନେ is it a matter of strategy or
No, not
that you do not want stay
ସେଇଟା
could be and I think that's a good thing yes और ଯଦି ଆଇଏ ଫାଇଲ କରିବେ ତାହେଲେ again it has to be listed with
Yes,
about this
sir.
matter ଆଜ୍ଞା
IF file କରିବି
କରିବେ then list for orders କେତେ 12 ତାରିଖ ଦଉଛନ୍ତି ନା matter shall be listed for orders on 12/3/2026
file.
जोड़ा भलो केस ସେଥିରେ ଆଇଏ କାଇଁ ଫାଇଲ କରିବେନି yes Mr. Sanjeev Kumar Vanjadev for the petitioner yes
May praise the Lord. I am from the wife, my lord. Marriage took place in the year 2021, my lord.
yes
And the husband has filed a divorce proceeding. So I filed the transfer petition for transferring the case from Judge Family Court Puri to Judge Family Court Chhatrapur Ganjam.
why
My lord, I am
why from Puri sir because the husband is in Jagannath
my lord, husband is belonging. I am for the wife, my lord.
I understand
Husband.
but yes Jagannath should find at Puri is
He
not
has,
Jagannath
filed, he
Sabha.
has filed the case at Puri.
yes sir he is the almighty
But my
how this court will direct Jagannath's petition to be transferred from Puri to Berhampur
assumption before your lordship.
because during that he was hidden at that is in the Paralakimundi, the other district. You must consider filing this application that when Jagannath is filing at Puri, you are seeking transport to Berhampur.
Chhatrapur.
Under what ground?
Ground, my lord, my parents, old parents, my lord. They are
Old parents, which provision in section 19?
also a distressed lady and undergoing financial crisis, my lord. And they drove me from that.
Sir, for distressed persons, Puri is the best place.
My lord, Chhatrapur
Chhatrapur is
ସେ ରହୁଛନ୍ତି ବାପା ତାଙ୍କ ଘର ବି ଗାଁ ବି ସେଇଠି ମ୍ୟାରେଜ ବି ସେଇଠି
yesterday petition was argued PIL before the Supreme Court. Tamasic character of garlic. Rasunara tamasic guna. PIL filage. But a committee form hobo. Somebody like you or Mr. Lenka will be there and so you should avoid transferring petitions who are distressed from places.
No, well, I am not there and till
These are not good grounds, Mr. Banjade.
also
Sir, which provision I will invoke? Section 24 says that convenience of the parties. You must examine the case law on this. There is no such provision that wherever you see once. Now suppose how many cases being distressed? How many cases you have filed against Jagannath? Sunita has filed how many cases against Jagannath? 98 has been filed.
ଏବେ ଫାଇଲ ସେ ଅପେକ୍ଷା କରିକି ନେଇଯିବ ବୋଲି ମାନେ such a lady she has filed
So when the lady distressed she files, she is able to file 498. She should pursue that.
ଏବେ ଯେତେବେଳେ ଯୋଉ ତାଙ୍କର ଘର ସମସ୍ତେ ଟ୍ରାଏ କଲେ ଯେ ତାକୁ ରଖିବା ପାଇଁ ଏକାଠି ରହିବା ପାଇଁ then my lord
498 essential ingredient କୋଉଠି ଅଛି ଯେ ଯଦି ମାନେ husband ମାନେ separation ହବ 498
no separation
କାଇଁ ସେଟା କହୁଛନ୍ତି
the allegation regarding torture and also they are taken away to the life of that has been reflected, everything reflected, how he has been tortured, how been broken away.
cause of action ଟା କୋଉଠି ହେଲା ସେଟା ଘଟଣା ଘଟିଲା ସେ ଟର୍ଚର କଲେ କୋଉଠି କଲେ
ଟର୍ଚର କଲେ but ଏମାନେ ବି ତା ଘରକୁ ଆସିଥିଲେ ତାଙ୍କ ଘରକୁ ବି
ଟର୍ଚର କଲେ ତାଙ୍କ ଘରେ ଯାଇକି ଛତ୍ରପୁର ଟର୍ଚର କଲେ
ସବସିକ୍ୱେଣ୍ଟଲି ଯେ ତାଙ୍କ ଘରକୁ ଆସିକି କରୁଛନ୍ତି
କେମିତି ହେଲା ଏଟା ପ୍ୟାରେଣ୍ଟସ ଆର୍ ଆବେଟର୍ସ ଆପଣଙ୍କ ଫ୍ୟାମିଲି ମେମ୍ବରଙ୍କ ପ୍ରେଜେନ୍ସରେ ଯଦି ଆପଣ ଟର୍ଚର ହେଲେ ସେ ଜଗନ୍ନାଥପୁରରୁ ଯାଇକି ଆପଣଙ୍କୁ ଛତ୍ରପୁରରେ ଟର୍ଚର କଲେ ଆପଣ ହବା କଥା
ଆମକୁ ବାହାର କରିଦେଇଥିଲେ ବା ପୁଣି ଆମେ ପୁଣି ଯାଇକି
ଯଦି ପୁରୀରେ ହେଲା ତାହେଲେ ଠିକ ଅଛି ବଟ୍ ଆପଣ କହୁଛନ୍ତି ନା ଛତ୍ରପୁର
ପୁରୀରେ ସେ ବାହାର କରିଦେଲେ
498 ଏଟା କୋଉଠି ଘଟଣା କୋଉଠି ଘଟିଲା
ପୁରୀରେ ଯୋଉ
କହୁଛନ୍ତି ଛତ୍ରପୁର ଫାଇଲ
ତାଙ୍କ ଘରେ ବି ଯେତେବେଳେ ଆସିକି ରହିଥିଲେ ତାପରେ ଯୋଉ ଆସିକି ନବା ଲେଖିଛି ଘଟଣା ଲେଖିଛି ମୁଁ ଟିକେ ସରି ସେଟା କହିବେନି 22/4 ମୋର ସ୍ୱାମୀ ସାବତମା ମତେ ପୁଣି ଥରେ ମାଡ ମାରି ମତେ ଜବରଦସ୍ତ ଆଣି ଗାଁରେ ଛାଡିଯାଏ ଚାଲିଯାଏ ତାଙ୍କ
ପୁରୀରେ ହେଲା ଆପଣ କହୁଛନ୍ତି
ଗାଁରେ କହିକି ଗାଁରେ ଆଣିକି ଛାଡିଦେଲେ
ସେ ମାନେ କହୁଛନ୍ତି ଟିକେ ରେସ୍ପେକ୍ଟେବିଲିଟି ରଖନ୍ତୁ
their intention to
nothing mister ଆପଣ ଯଦି ଡିଷ୍ଟ୍ରେସ୍ ହେଇକି 498 କରୁଛନ୍ତି 302 so you pursue your litigation at Puri because the occurrence is ଆପଣଙ୍କ ଟର୍ଚର ହେଲେ ପୁରୀରେ ଛତ୍ରପୁରରେ କେମିତି କ୍ରିମିନାଲ କେସ୍ ହବ
ଲାଷ୍ଟ କୁ ଯୋଉ ଛାଡିଲେ ଆଣିକି ତାଙ୍କ ଘରେ ବି ଛାଡିଲେ
ସେ ଯାଉଛି
ସେଟା କଣ୍ଟିନ୍ୟୁଅସ୍
କଣ୍ଟିନ୍ୟୁଅସ୍ କୋଉ ସେକ୍ସନ ରେ ଥିବ ନା
torture 498 I guess these are all continuous process of
କୋଉଠି ଆପଣଙ୍କ କାହାକୁ ନେଇ ଗାଡିରେ ଛାଡିବାଟା କୋଉ ଅଫେନ୍ସ ସେଟା କୋଉ ସେକ୍ସନ ରେ ଅଛି ପଢିଛନ୍ତି କେବେ 498 କିଛି ଗୋଟେ ପଢିଛନ୍ତି କନଫାଇନ୍ ଆପଣ କହୁଛନ୍ତି କାହାକୁ ଛାଡିଦେବା ଅଫେନ୍ସ
ସେ କହିଲେ ଘରୁ ପଇସା ଆଣିବା ଡିମାଣ୍ଡ କରୁଛନ୍ତି ବି 3 ଲକ୍ଷ ଟଙ୍କା
ଜିନିଷ ଆପଣ ଯୋଉ ଟର୍ଚର ଇଏ କହୁଛନ୍ତି ସେଟା ତ ପୁରୀରେ ହେଲା ଆପଣ
ପଇସା ବି କରୁଛନ୍ତି ଡିମାଣ୍ଡ ବି କରୁଛନ୍ତି
ଆପଣ ସେକ୍ସନ 24 ରେ there is no provision ଆପଣ 498 ଯୋଉଠି କରିବେ 498 ତାପରେ attempt to 507 ଆପଣ ଯୋଉଠି କେସ୍ କରିବେ ସେଠି ଫ୍ୟାମିଲି କୋର୍ଟ ହବ ସେଠି କିଛି ନାହିଁ 19 ରେ କି କେସ୍ ଲା ବି ଡେଭଲପ କରିନି ଯଦି ଅଛି ଯେ ୱାଇଫ ଯୋଉଠି 498 ଏଫଆଇଆର ଦବ ସେଇଠି ଆଣନ୍ତୁ what you are arguing is bereft of law still I will accept it no difficulty for accepting your submissions which is completely divorced section 19 IPC CRPC nothing works in your favor because you have filed a 498 case at Chhatrapur 30 months should also be tried at Chhatrapur there is no such law if it is there then please bring that so that I can pass the order
and another thing my lord
sir let us not have a general drawing room discussion ଯଦି କୌଣସି provision relax କରୁଛନ୍ତି Hindu Marriage Act ରେ ଅଛି Family Court Act ରେ ଅଛି straight away go there let us not have a debate general kind of discussion because that's a specific question to you if you are tortured at Puri then why you are filing the FIR at let us assume you can file FIR anywhere let us assume that also now your point is that since I have filed a FIR in Chhatrapur the section 13 has to be filed at Chhatrapur
another point my lord the father and parents they are also moving from Chhatrapur to my lord Puri
sir why the lady is taking her their parents to Puri she should file an application in which provision the parents of the lady to appear before the family judge
distress letter to pun ke oda adding
distress sir she's distress she is so that cannot be a ground
and another thing the
when we Mr. Hon'Ble we have started reading the law wrongly Ajif only the 24 is very clear convenience of the parties nowhere it says that wherever the FIR is filed by the lady the 13 has to be transferred it is not there
and
section 9 says that the civil court shall try all cases so under which provision I will direct transfer and you are taking plea of the wife the husband the parents of the lady will appear before the family court
parents may let somebody will take her to the.
So later appear to CP.
You
must understand that the work of Puri Court and work of Chhatrapur Court has to function. There will be many. So if this is a precedence, High Court creates a precedence. So for that you cite some case law. Not common sense, because our
basis of settlement
there in 13. You must understand, in a 498A there is no settlement. It is not compoundable. Is 498A compoundable? You will always grievance. See, what is the punishment in 14 years? 498A? 10 years.
7 years.
7 years, he will be punished and he will compromise with you in 13. If you want compromise, allow the proceeding to continue at Puri, appear there, conciliate, or cite some case law.
The Lordship may fix another criteria.
Of course. Usually I am not dismissing, but that doesn't mean that I have to pass wrong orders, giving a wrong interpretation to law. Convenience of the, if it is there, then you cite some decision.
Yes, Lordship may.
The application has been filed by the wife in the marriage, seeking transfer of the CP number 277 of 2025, filed by the husband in the marriage. On 8 August 2025. The said CP was filed by the opposite party husband under 13 into bracket. You take your seat. I'll dictate. I'll take some time to dictate the order. 13 into bracket English 1 to bracket 1A. Currently, after filing of the CP and receiving notice in the CP, the wife has filed FIR dated 05.02.2026. Before the थोड़ा जेटा
Right, my lord. Gram Gonjam PS case number 31/26.
थाना ना ग्राम पंचायत थाना डा कोंतु
Gram Gonjam
ग्राम गंजाम कर्म
se thana na.
थाना डा ग्राम गंजाम
Page 11 to.
in this is a revelation to me. I had no idea. Vishwanathpur God's names there are thanas, but in Gram Ganjam, I read that, but I thought that it is something else in the district of Ganjam. In the said FIR, apart from the opposite party husband, there are 9 other accused persons who are family members of the opposite party husband. Allegations having been made under section 294, 307, 323, 498-A, 506, read with section 34 of IPC, and section 4 of Dowry Prohibition Act 1961. The learned counsel for the petitioner has adjournment to address this court under which provision the matter can be transferred to Gram Ganjam to the court to Chhatrapur in the district of Ganjam, particularly in view of Section 19 of the Hindu Marriage Act, Section 9 of the Code of Civil Procedure Code. List in the week commenting 13/4/2026. Yes. जेल के दिन जेल रे आपण फैमिली मेंबर के दिन रहले डिस्ट्रेस लीडिंग ऑफ फैमिली मेंबर को जो बन तो अरेस्ट हे जैतिबे
ना ना के जे के ना तार पुलिस वाला सब चिन्हा किछि ए लोग अंगर किछि माने सेमती
पुलिस वाला कहार चिन्हा तल काई सेठी नोचंदी आपण छतरपुर पुलिस तार चिन्हा आपण पूरे केस करिया कथा
सब
माने भारत सारा तांकर चिन्हा. Then I am correct actually. I was making a lighter effort that then actually he is Jagannath. You should try his case at Puri. What you are saying, you are elevating your husband to the level of Lord Jagannath. Tankar samaste chinna. Government case ta distress no. Government case is dodiba. There are several. Our case law is replete with incidences where the wife is impeding.
My humble son,
And
this took place 25.
and you
Till
look
25
and you, and you look at the mistake you have made. Junnu Baitaru, Runu Achari, all are from Malud, Krishna Prasad. They are married since long. They are also distressed and staying with their parents. Like you are now, suppose now you are having sister-in-law. Now she will be tortured. You are accused maybe because now you are staying with your parents. But all the ladies are staying at Malud Krishna Prasad.
बापा घर लोक
पूरा ये कर कस्मिक लेवल को नहीं गले से जड़े रही से रे आसी पड़ से टॉर्चर हो गला
नहीं से जितने टॉर्चर है बिगिनिंग
sir this tells the usual sad story that when you are instigated or you instigate somebody to make lodge false complaints. Yes, next. आप कौन डोमेस्टिक वायलेंस भी करचन
नहीं डोमेस्टिक
ठीक है. Mr. AP Bose for the petitioner. DN Lenka IGA for the state. Yes, please.
Well, the sale deed was executed in my favor. That was stated to be undertaken.
This is my assignment.
In fact,
Yes, sir. Yes. Last time your lordship has,
it was listed before Honorable
your lordship may see the note, flag 20. Put up by the second.
Flag
And then the-
20. No, flag 20.
State legal.
Yes, sir.
No, flag 20.
सर्टिफिकेट केस बट आपण अंडरवैल्यूएशन चैलेंज करछथि ना
नहीं सर
खाली सर्टिफिकेट चैलेंज करछथि
सर अंडर वैल्यूएशन है कि सेटा गला सर्टिफिकेट ऑफिसर तो इनिशियली द एडीएम वाज द एप्लेटर माने अथॉरिटी टू आइडेंटिटी देन इट वाज ट्रांसफर्ड टू द कोर्ट ऑफ स्पेशल सर्टिफिकेट ऑफिसर he was
designations special certificate officer
he is sub collector cum special certificate officer special certificate officer office of sub collector Bhubaneswar. The sub collector becomes the special certificate officer. That was kept pending and my objection was not heard. I came up before your lordship in a writ petition. In this writ petition, your lordship may kindly turn to page 53.
Before this court, the challenge is to the certificate proceeding.
No, non-consideration of my objection to the proceeding of certificate officer before the certificate officer. Your lordship may see paragraph 3. in view of the limited grievance of the writ to application is disposed of, directing special certificate officer Bhubaneswar to dispose of the matter as early as possible, taking note of the objection dated 6/10/2021 filed by the petitioner before ADM, as well as the objection dated 3/2/25 filed before the present court. But initially I said it was ADM was there, then it was transferred to the court of special certificate officer. So both
that order valuation is whose order?
There is no order to that. Once the stamp
or you can say who has found out or who has given the finding?
is the district sub-register.
DSR.
DSR. Once it is held, it is found to be undervalued as per their own assessment, they will refer to the court for adjudication.
Which court? Civil court or?
No, ADM.
ADM.
ADM is the authority. Because your lordship knows under the stamp tag.
He is the district registrar.
District registrar. So it was.
So DSR sent to DR.
DR.
Okay.
DR, the government made a notification. No, now not DR will not hear. It will be the special certificate officer will hear.
He is the appellate authority.
No, appellate authority is the IGR.
No. Against the report, the order valuation report is sent to.
ADM becomes now the appellate authority.
The appellate will be first hearing the order valuation case.
Yes. Then appeal flies to the ADM.
The notification is there.
Well, the notification is not there. I don't know. Here notice it is not in dispute. You are also.
No, I am thinking something else.
Yes.
Dispute. Registration manual ta pade gala. Yes, please carry on.
Yes. Then this honorable court consciously directed both the objections to be decided by the
special certificate
officer. This was the order I communicated. Now the lordship may time turn to page 55, annexure 14. Your lordship may say annexure 14. In inviting to the reference to the subject above, my lord has got it.
Yes, yes.
It is hereby informed that as per the order of the Honorable High Court of Orissa, such and such, you are directed to appear before the court on 8th day at 3:30 p.m. for payment for certificate dues. Well, where he has considered my objection, he directly says you come and make the payment. And interestingly,
the way we use English.
Yes.
They said that that is the reason actually the independence, the Britishers left us. They could not, anymore withstand the use of English language by us. And as such, me coming from vernacular background, we give stress on grammar and all that. Maybe a mistake. I don't think that is intended after High Court order.
Yes, sir.
Mistake.
My lord, may kindly see the case number.
No, now, Mr. Bose. Already there is an order by a court.
Yes.
So that order, I can simply say that order is reiterated. He has to consider before passing order.
That much I want.
And the honorable court, coordinated bench of this honorable court,
yes,
has granted certain time that has not been expired.
Sir, this is the language
So your lordship can remind the matter to.
Skandhanga badhate rajan, taba badhati.
Sir, the officer.
I mean,
Your lordship is absolutely right. There is a mistake by saying this. He could have written. Today I have talked with the sub-collector.
Vikram, who tried to torture Kalidasa and asked him to carry the palanquin. I think the king was very happy. He said that you carry my palanquin. So he started carrying.
My senior.
When he asked the question, so the language, this grammatical mistakes, Skandham King Badati.
Today I have talked with the sub-collector in the morning.
So instead of Badati, the king should have asked Skandham King Badate. So that grammatical mistake he committed while laughing at Kalidasa.
Lakshmi.
And the case number itself is wrong.
ସେଇଟା ଭୁଲଭାଲ ହେଇଯାଉଛି ଆଉ କଣ କରିବା
Sir, ସିଏ କହିବେ payment ଦିଅ, ମାନେ he sits over the appeal of the Orissa High Court.
ସେମିତି ମିଷ୍ଟର ଲେଖା ତ କହୁନାହାନ୍ତି ଆଉ ମୁଁ କେମିତି କହିବି
Sir, ସିଏ କଣ କହିଥାନ୍ତି କି king can do no wrong?
No, no.
That is a good word.
Both the
It's a mistake is a mistake ଆଉ କଣ you have to
Sir, these officers should be prosecuted so much by your lords. Then only the administration will be okay.
Mr. Bose was also, Mr. Bose was also this side.
Sir,
Mr. Bose,
sir, it's a mistake. I was never in the government side.
Mr. Bose, there I have an answer. The higher we are, the kind of when position we are holding, we should be also very circumspect as courts.
Sir,
Not as a judge.
Sir,
I'm saying that's correct.
it's okay.
ସେଇଟା ଗୋଟେ mistake ହେଇଯାଇଛି ଆଉ କଣ
You
କରାଯିବ
can punish as the author.
ଆପଣ ଯୋଉ କହିଲେ
ଆଜ୍ଞା
ସେ କହୁଛନ୍ତି ଯେ ଏଇଟା ଭୁଲ
ସେଇଟା ତାଙ୍କୁ ଡକା ହେଇଥିଲା ଟୁ appear before him regarding hearing of that objection. ସେ ଲେଖିଲା ବେଳକୁ ଏଇଟା ହେଇଛି ଆଜି ସକାଳେ କଥା
Sir, this order has to go then.
ସେ କଣ ରାତିରେ ଅଲଗା ପ୍ରକାର କଥା ଡିଫିକଲ୍ଟ ହୁଏ କି ତାଙ୍କ ସାଙ୍ଗରେ
then today morning
today okay no why you are choosing the morning hours
because I have I go
acha
to
you did the brief late in the wee hours late night
3 a.m. not in the first hour.
you are starting at 10 or waking up at 3
I go to bed by 10.
okay
My senior,
he maintains that habit good habit of sleeping early
my lord, my senior is quite senior to me. But with due respect, I would say to my senior, I have never been a government counsel.
No. Arey say that again, sir. If he says he has the impression that you are a government counsel.
Yes, he is AK Bose. He is Anup Kumar.
No. AK is senior to him also. By age and.
No, I
No, sir, no question of withdrawal. Just clarification. Sir, then this order has to go. Let me fix a date on which I'll appear and let it be heard and it will be disposed of its own merits.
yes.
Taking into consideration the previous order passed by this Hon'Ble Court.
By order dated 27/1/2026, the court bench has fixed time.
Yes,
Six
it can
weeks.
fix time 6 weeks.
6 weeks. Page 54, second line.
The writ application filed by the petitioner boils down to a narrow path after the learned counsel for the petitioner and the learned AGA are heard. Appearance section in Mr. AP Bose for the petitioner, Mr. DN Lenka, the state opposite part. Appearance. Learned counsel for the petitioner takes exception to the order dated 10/2/2026. Annexed to the writ application marked as Annexure 14, where the following has been directed. The following has been indicated. पूरा आरंभ टू की शेष जाए लिखिदेवे बस स्कैन करी रिप्रोड्यूस करते हुए जहाँ करी पर It's Leka, you take your seat.
Yes.
The said order is pursuant to the order passed by the coordinate bench. That is page, Mr. Bose.
Well, the order of this Hon'Ble Court,
Yes.
that is
53.
53. Order passed by the coordinate bench. Order dated 27/1/2026. Coordinate bench in WPC number 1812 of 2026. Disposing of the petition. The orders or the paragraphs 2, 3, and 4 of the said order are reproduced herein. Referring to the order of this court at 27/1/2026, it is submitted by the learned counsel for the petitioner that the special certificate officer has exceeded his jurisdiction in directing the petitioner to pay the certificate dues without considering the objections of the petitioner dated 6/10/2021 filed earlier before the ADN. Additional full form like Additional District Magistrate.
No, 2001, not 21.
21 6/10/2001. 6/10/2001 filed before the Additional District Magistrate, before whom the proceeding was pending, as well as the objection dated 03.02.2025 filed before the special certificate officer.
Office of Sub-Collector.
Special certificate officer. That's Office of Sub-Collector, Bhubaneswar. On the face of it, the submission of the paragraph, on the face of it, the submissions made by the allotted counsel for the petitioner is correct that the order dated 10/2/2026 issued by the special certificate officer has not followed the directions of this court, that is order dated so and so passed by the coordinate bench. Stop. The lauded AG in response submits that apparently the language used in the letter dated 10/2/2026 regarding payment of the certificate dues is not in sync with the order passed by this court earlier. And the said order is a mistake. The officer never tried to, the special certificate does not intend to act contrary to the direction of this court. To that effect, he had a telephonic conversation with the officer and has received the instruction. In view of the above, the order dated 10/2/2026 is order letter. The letter dated letter number 1247 dated 10/2/2026. To the extent it records, quote, for payment towards the certificate dates is set aside and quast. The special certificate officer shall comply with the order dated so and so, and consider the objections of the petitioner as directed earlier by the order dated so and so in WPC so and so. The period for consideration and decision in the matter is extended up to 6 weeks.
4 weeks.
Extended up to 31/3/2026. The petitioner shall appear before the special certificate officer along with certified copy of this order on
16th.
On 16 ହେଲେ ତାହେଲେ 16 23 30 up to 6 କରିଦିଅନ୍ତୁ, up to 10th April କରିଦିଅନ୍ତୁ.
Yes.
Up to 10 April 10/4/2026. The petitioner shall appear on 16/3/2026.
And he shall fix a date of
on the said date, the officer shall fix a date for consideration of the objection and hearing of the matter. Sorry?
Hearing of the both objections.
Hearing of the objections plural करते as directed earlier. ସେଇଟା ନହେଲେ ଆଜ୍ଞା ଆପଣଙ୍କର ଓକିଲ ଆପଣଙ୍କର ଇମ୍ପୋର୍ଟାନ୍ସ କମିଯିବ। ଲିଙ୍କାଙ୍କର ବି କମିଯିବ। ସିଏ ବର୍ତ୍ତମାନ ତାଙ୍କୁ ପଚାରିଲେ ଆଜ୍ଞା କଣ ଆପଣ ଲେଖୁଛନ୍ତି ଏମିତିଆ।
Retribution disposed of.
The writ application stands disposed of. With the above observations. Urgent certified copy as per rules.
Right.
Mr. Arjun Charan Behra for the petitioner. Yes, Mr. Behra. Mr. P.N. Lenka, IGA for the state.
Inaction of the sub-collector, my lord, opinion number 3. The advertisement made by him, my lord, in the year 2002, getting recklessly of fair. I have also applied my lord.
Instruction tale diyantu. Any roadblock achi ethire?
No.
Lapse kariba nahi.
Yes,
There can be two possibilities. There is some roadblock or this notification has lapsed. There may be some statutory mandate which I do not know. Offhand, I cannot say. So you take instruction.
Yeah, what your lordship. But Annex 3, he has filed a representation. That is pending.
No, representation regarding not his rights. The problem is, I may write, he may file a representation regarding his rights. Regarding something notified by the sub-collector.
I'll take it. Yes.
The petitioner alleges, the petitioner in the writ application is a villager, I can't say.
SSG group secretary.
He's secretary of a self-help group. Second, intending applicant.
My lord.
The self-help group. And is secretary. The secretary of so and so, secretary of Vishwa Kambhunath, as a self-help group, Patana. Under Ratnagiri Grama Panchayat, the district of Jajpur.
Yes.
Stuff. The petitioner alleges inaction on part of the authorities. Pursuant to the notification dated 21/22 into bracket 1 to the writ application. Issued by number 3 sub-collector sub-regional magistrate Jajpur, inviting applications for engagement of person na kon ho
Fair price of
kon pai kahaku engage karibe
retailer
for engagement of retailers for fair price shop for the village apanko ko village Ratnagiri apankara Patana for the village Patana
Under Ratnagiri GP.
Ratnagiri to डाक दीजिए dictator. Para. The learned AGSL has adjournment to obtain instruction regarding the reasons of further action not being taken by authorities pursuant to the notice dated 21/22 সেটা 6 বেলা দেখা যাচ্ছে 6 তো নয় এটা জানুয়ারি 21/22 the week commencing
Lakshmi 2 weeks.
Listen, the week commencing 13/4/2026 stuff. It's further clarified that pendency of the petition shall not be any bar for the authorities to take action.
Consider Annex 3.
For advertisement dated 21/22. Because I don't think he can make a representation. The reason being that he may have a claim. This SSG, other SSG. So whoever are applicants, they will be considering them. If he has been told that upon the High Court order, that should be taken care of. Yes. list.
We have a copy of the order.
Copy of the order shall be, the copy of the order, the parties to act upon, the copy of the order available at the official website of this court. Copy of the order shall also be handed over to the learned AG.
Right.
Yes, next. Santosh Kumar Dwivedi.
My lord, may I please
For the petitioner.
talks of the matter, your lordship. The marriage between the petitioner and the opposite party, your lordship, is seriously disputed, your lordship. And without considering that
125 has been awarded.
Yes, your lordship.
You have to file review before Supreme Court.
Hello.
You have to file review before Supreme Court. When the marriage is disputed, see this, what the Supreme Court has said. And at your level, you should argue always crisp on sharp on law.
Yes.
30, 37, 38 देखो, 37 देखो. You are expected to whatever may be the case, that's a different thing. But lawyer is completely independent. This is the charm of your profession.
My lord, in this case, what I'm just
So it is a matter of evidence.
My lord, that's right.
So if you want to challenge, now the next point is that this proposition of law is incorrect. In 125, even live-in relationship.
It is not a live in this
Then look at Chanmunia. Supreme Court in Chanmunia. So just 39.
There is no living relationship. That is the thing. My lord, she was simply.
Problem है कि आपण पढ़ी के आसिलेनी जो कोर्ट रिक्वेस्ट कले पढ़े पे पढ़ुना.
Of course, देख सकते
So you are making the worst argument which will against your client.
No, that's right. I'm saying.
So then you have to file review of this larger bench, Supreme Court. This judgment was referred to a larger bench before the Supreme Court. It was held that where a man and woman have cohabited for a long period of time in the absence of legal necessities of a valid marriage, such a woman would be entitled to maintenance. This you have to file review there, not here.
That's why I'm saying you.
So now your problem is that you have backed up a wrong tree.
No, my lord.
125, you have tried to disprove the marriage or deny the marriage. There you have failed. Now you want to challenge.
No, my lord.
So you secure the decree here and notice be issued.
No, my lord.
Without securing the decree, no notice.
My point. What has happened, your lordship?
Then Mr. Dwivedi, you must understand that when I started with a serious note, I'll record, give the reasons and reject your contention and grant you adjournment.
My lord,
I have to. I do. After Supreme Court, I'm not sitting here when review of Supreme Court judgments or have a relook.
So therefore, I'm saying.
Much less being a single judge. Division bench only, I can take a parallel view at least in some cases.
No, I'm not saying that because you are not. I'm not saying that your lordship will.
No.
Judgment of affairs.
So that is why we are avoiding to read that.
No, I have read your lordship.
That's the problem. Now, Mr. Dwivedi, suppose I accept your contention that the petitioner's marriage is seriously disputed and the learned trial court has not taken note of that aspect. Just now you submitted that.
But that's
Can I do that?
sort of-
I cannot do that in RTFM.
No, yeah, this is actually, my lord, on the section 24 application, I have, it is.
Sir, 24 is still, then that is another problem. Then you have to read further. Interim maintenance clear. Just a पूर्वटा पढ़ନ୍ତୁ पूर्व पेजटा जोटा आपण 34 पढुଥିଲେ ए 62 टा देखନ୍ତୁ सॉरी परटा मु उल्टा कहि पारा 62 पढନ୍ତୁ आपण डिवोर्स फाइल कले ना सी फाइल करछन
डिवोर्स नहीं सर,
सेक्शन 9 फाइल करछन
सी सेक्शन 9 फाइल करछंती
आ सेक्टर 24 फाइल करछन
हां से कोन हेजी।
सो द प्रॉब्लम इज दैट
ठीक है सुनिले
सो आपणकर प्रॉब्लम हला आपण तो मु तो सुनुनी आपण कथा आपण ना बिल्कुल पढुचंती ना प्रिपेयर होचंती केस पई आपण कोन होचंती आपण जहा क्लाइंट कहिला सेटा को आसी कि एठी रिप्लाई करचंती टेप रेकॉर्डर होल दिस क्वेश्चन यू हैव टू आस्क टू योर क्लाइंट I need not assist you. The lawyer then there are lawyer और client भितर कौन तफात रहला तो निजे आर्ग्यू करिवे and I am yet to see a person who understand law and arguing in qualified in law. Service matter argue करती जे हमें जे चाकरी को हमें करिवु but the basic simplest point make up. अपन जदि पढन्ते बड़ पेटर देला एटलिस्ट मु जाई पड़ते अपन कोन पढुचंती 62 रे कोन कहले
62 रे मतलब द प्रोविजो
so आपण सेक्शन 24 जदि डिनाय करूचंती देबेनी बोली then what is the ground you can deny section 24 the court has to adjudicate
yes lord
so your written statement
the proviso to my lord what is so therefore I wanted to I have read this judgment your lord
sir you have read but you have read ignoring the portions which is against the petitioner.
I
the first thing you do
therefore I
that try to grapple with the proposition of law which is against you.
Yeah, no, that is.
Then you have won the case.
Yes,
Then you have won the case.
I agree.
Yes. So that is my understanding of whatever practice I have made. The base points against me if I am ready.
Exactly, your lord.
So now then have you read 62?
I'm reading it.
So we'll come back after research because it requires hearing. We cannot finish it in 5 minutes.
I may you like my item 23.
You sir work ଅଛନ୍ତି
my lord
I am 23.
please ଆପଣ ରଖନ୍ତୁ ମତେ ଦେବେ
I would my lord I have this judgment.
62
I have this judgment.
after spending 10 minutes 15 minutes let us not waste the time.
No, I'm saying
ଆପଣ ପରେ ଦେବେ sir ମୋର ଏବେ ସାଙ୍ଗେ ଦରକାର ନାହିଁ.
No,
you can keep it.
I have the copy here. That is
okay you have Rajnish versus me.
Yes, yes.
Okay.
My lord may I
account nova
may I pray your lordship because I have some other date.
But whatever we have discussed today that
yes I will keep it in mind your lordship.
No and I'll pass that upon date कोंतु केबे सर कोचन date कोंतु 6/4 ना केबे चाहछो कि 6 तांकर 6/4 सुविधा होता है लिस्ट करे बेटा पूर्व चाहछन ताने से कोन करिबम कहि परिबेनी आपनकर 14 रे ऑर्डर डका हबो डेटा लिखि देबे वी कमेंशन 6/4 आपनको जोतरे एडजर्नमेंट चाहछंती माने रादर 22 चाहछन एडजर्नमेंट
23. Today I just now appeared my lord. My file may boklam nama.
म्हणजे सेटा तो ऑर्डर वाले हबन I am not taking any matter out of turn to pass orders. That doesn't look good. आपण जदि रहिबेनी just inform any of your colleague.
Only for that reason I am.
Whatever, sir, you can leave no difficulty. You can send any request any of your friends. But just taking up the matter like that is not a good thing. Yes.
Pardon, my lord, item number 8, I could not item number skip.
8 टा कोन ଆପଣ କରିବେ ଆର୍ଗ୍ୟୁ କରିବେ
my lord.
ତାହେଲେ 5 ଓଭର କରିଥିବେ
2 PM.
ଏଇଟା ଆଉଥରେ କଲ୍ କରିଦେବେ ଯିଏ ମେନସନ କରୁଛନ୍ତି ଅର୍ଡରଟା ମଗେଇକି କରିଦିଅନ୍ତୁ ହେଲା ଫାଇଲଟା ମଗେଇଦେବେ ଆପଣଙ୍କର ନେକ୍ସଟ ଡେଟ୍ କେବେ ହେଇଛି କହିଲେ ଆଇଟମ 8 ଟା ଡେଟଟା 6/4 ଅସୁବିଧା ଅଛି
ହଁ my lord ଆଜି ଟିକେ ମୁଁ ରେଡି ଅଛି କର
ଆରେ ନାଇଁ 6/4 ରେ ଆସିଲେ କିଛି ଅସୁବିଧା ଅଛି ସୁଧା ଫାଇଲଟା ରିକଲ୍ କରି ଆଉଥରେ ତାକୁ କରେକ୍ଟ କରି ଦରକାର
ଟିକେ ଅସୁବିଧା
ନନ୍ ରେଫରେନ୍ସ ହବନି
ନା ଆଜି my lord ମୁଁ ରେଡି ଅଛି
ତାହେଲେ ନେଇ ଆସନ୍ତୁ ଫାଇଲ ଆଣନ୍ତୁ
oblige
Just give me a moment. That matter order was not dictated. It so happened that I could not again manage that. So Santosh Kumar Dwivedi for the petition. Item 14 upon lecture. The petitioner husband in the marriage is before this court. The petitioner is before this court. Husband challenging the order dated 22/1/2026, passed in IN number 56 of 2024. Arising out of the CP number 276 of 2023. The said CP to order लिखेंगे order dated order dated by 6/2026, passed by the learned judge, family court so and so. Family court Raukela. I the number petition. Arising out of CP number is the election. The said CP number 276 of 2023 was passed by the was filed by the opposite party wife in the marriage. The IA number 56 of 2023, arising out of the said CP, was filed under Section 24 of the Hindu Marriage Act, read with Section 151 of CPC, seeking pendente-like maintenance. The prayer made in the IA was for rupees 20,000 per month. Towards maintenance, such as clothing, medical expenses, house rent, and rupees 25,000 towards legal expenses, litigation expenses. The IA was favored. However, directing directing the husband in the marriage to pay a sum of rupees 20,000 per month from the date of filing of application, that is 30/10/2023, and 3,000 was directed to be paid towards litigation expenses. The opposite party before the learned judge family court the opposite party wife had produced two marriage photographs, for persuading the court regarding the marriage, and had also produced the salary certificate for October 2025 from the Senior Divisional Personnel Officer, Southeastern Railway, Chakradharpur, indicating the gross salary to be rupees 1,94,021 and net salary to be rupees 1,29,487. The learned court has taken note of two children two children The learned counsel for the petitioner was heard at some length. It was brought to the notice of the learned counsel for the petitioner the enunciation of law made by the Honorable Supreme Court in Rajneesh versus Neha. Rajneesh versus Neha, bit of Neha, into bracket 2021, bracket close to SCC 324. Paragraphs 62 and 63. That limit of interim maintenance as provided in section 24 of the Hindu Marriage Act. The learned counsel was also requested to go through the paragraph 13, 14, 38, and 39 of the said judgment of the judgment with Rajneesh versus Neha Tripura. As it is contended by the petitioner before the learned trial court that he disputes the marriage with the opposite party lady. Learned counsel 6 adjournment. 6 and has adjournment. Stop. The matter shall be listed for it. Account पे आश्चर्य जी कितना नंबर आइटम 14. The matter shall be listed for fresh admission in the week केबे कहले 6 in the week commencing 6/2024. 500 ଭୋଟ ଯୋଡ଼ାକ ନନ୍ ଆପିୟରାନ୍ସ ଥିଲା ସବୁଗୁଡ଼ା ଡାକି ଦିଅନ୍ତୁ ଆଗରୁ ଥିଲା ନା ଠିକ ଅଛି ଡାକି ଦିଅନ୍ତୁ ଏଇଟା 14 ଗଲା ମାନେ ସିରିୟଲି 14 ଗଲା ଏବେ 500 ଭୋଟ ଡାକି you Mr. Mr. Saroj Kumar Rautray for the petition. Yes, Mr. Raut.
My lord, kindly have a glance at 13 to 26.
এটা जो ফাইলটা ফেরিলে আপনারা দিয়েছিল কইলে তো কই দিয়েছেন তো Yes, please.
Kindly have a glance at 13 to 26, my lord.
Acha, yes.
That list of views appointed in different districts. Recently.
Oh, so yes, that I was actually I was referring, just going to refer to that.
My lord.
Now this is the time for annual general transfer.
Yeah, my lord.
The regular transfer,
regular transfer.
So it will be taken care of. because apart from you, some very senior members of the bar, which I just met as a chance. They also said that I have no work. I said that, are you coming to court or not? A very senior person. He said that you have closed courts, why I will come to court? Then he said that no judge is there. That he said.
But 19 to 20%.
So this was after this. So 19 to somebody has been posted.
Now 19 to 26, that high court notification that there are some of list of views are appointed.
Then there somebody has appointed.
They are from Malkanagiri, coming Babita Das, namely.
Then you have to give more time. There is some transit period given to each officer.
I contacted the court master. Court master told me that in a week.
Regularly it is being done. But now this is since general transfer. So you contacted the court master in which day?
Last days there. 3 to 4
So
days.
you can adjourn it by 2 weeks.
1 week.
2 weeks better. At least you will be satisfied that you have played the role in getting the judge being posted.
No, I don't know.
Definitely.
But
I mean,
I gone through the notification.
Sir, you are also correct that not exactly, but at least you made the effort approaching the court. And I think he resigned actually. So who was presiding? He
resigned. He resigned from his post.
So, I mean, in case of resignation, it gets a little bit more complicated. Unless the resignation is accepted, he continues. And if he continues, that post cannot be filled up. Most likely, after acceptance of resignation, the annual general transfer, somebody has been posted.
There are 75 to 76.
Correct. It is an annual general transfer. The allotted refers to the earlier orders between 21/1/2026 and 13/2/2026 and submits that in the notification issued by this court dated 19/2/26 notified a posting of several officers. An officer has been designated to be posted as senior division Athavada. The matter is adjourned. We listed for orders in the week commencing with the 10th. Commence 3 7 दिन को चल
7 days.
Let's face last week. 30 दिन कर दिले ना 30 से छुट्टी है. We commencing
23
दिन था. Yes, that's.
Item 15.
Serial देखिए. आप कुछ ना पास और पीछे नहीं बनती.
Nice.
ये फिर तो सर.
Blood.
Mr. Tendo Kashyap, Senior Panel Counsel for Appellate.
They applied. Your lordship, in this case, I filed
Mr. Rohit Rai is not visible. He is in DC.
Sure. I am your lordship.
He is there.
Malo.
Rohit Rai को बड़ा कर दिया तो. अगर for MPL, set up professional on file. Audio settings.
A deficit court fee has been calculated in this case, and accordingly, I have deposited. ନାଇଁ ଫାଇଲ ହେଇଛି
ତ ସେଥିପାଇଁ କେବେ ଫାଇଲ ହେଲା କେବେ ଲିଷ୍ଟ ହେଲା ସେଟା ଦେଖିବାକୁ ପଡିବ
ମାନେ
ନାଇଁ ମତେ ପଚାରୁନି ମୁଁ ଆପଣଙ୍କୁ ବିଶ୍ୱାସ କରୁଛି ଆପଣଙ୍କୁ ତାରିଖଟା ପଚାରୁଛି ସେଥିପାଇଁ
ଆଜ୍ଞା ଏଟା ଫାଇଲ ହେଇଛି ଆଜ୍ଞା 13/11/2024 13/11/2024 ରିସିଭ୍ଡ
ଆପଣ ବି କିଛି ଦେଖୁନାହାନ୍ତି କି ଫାଇଲ ଫାଇଲ ଆପଣ ମାନେ ଆପଣଙ୍କ ଅଫିସରେ କହୁଛନ୍ତି 13/11/24 ଆପଣଙ୍କର R1 ଯୋଉ କ୍ୟାଲକୁଲେସନ ସିଟ୍ ଫାଇଲ କରିଛନ୍ତି that is on record
ଆଜ୍ଞା
ଆପଣଙ୍କ
On the
calculation
basis of
sheet ଟା
that-
ତାଙ୍କୁ ଦେଇଛନ୍ତି?
ଆଜ୍ଞା ଆଜ୍ଞା ପାଇଛନ୍ତି ବୋଧେ।
Mr. Roy,
Your Lordship, the deficit could be, as your Lordship held, was 5,201.25 paisa. They have stated that amount what is less by 267 rupees only. It's your Lordship, up to your Lordship.
ଆରେ କାହିଁ ସେଟା 267 ପାଇଁ କାହିଁ ଆପଣ ତାଙ୍କୁ
ନାଇଁ ଆଜ୍ଞା madam kindly see one
ଶୁଣନ୍ତୁ, ଆପଣଙ୍କର
dishonorable
ଯୋଉଟା
court.
ଆପଣ at least right now still it is determined 267 କଣ ଦେଇପାରିବେ?
ନାଇଁ ମୁଁ ଦେଇପାରିବି ଆଜ୍ଞା ଅଫିସ ଡିସାଇଡ କରିଦେଲେ ବୋଧେ 4602 ଅଫିସର କାଲକୁଲେସନ ବି ଅଛି ଆଜ୍ଞା ଏକ୍ସଟ୍ରା ରେଜିଷ୍ଟର
ନା କୋଉଥିରେ ହେଇଛି ସେଟା?
ଆଜ୍ଞା ସେ କାଲକୁଲେସନ directed coordinate bench of this honorable court on 28/10/2024 that the registry will verify whether the 5201 is payable or whatever will be the amount.
ଆରେ ସେଇଟା ତ ଆପଣ ଗୋଟେ ଫେରିବାର going again back gear ପଳେଇଲେ।
ଆଜ୍ଞା
ଆପଣ ଦେଲା ପରେ କୋଉ ଦିନ ସେଇଟା ଡିସାଇଡ ହେଲା ଷ୍ଟାମ୍ପ ରିପୋର୍ଟ କିଏ କଲେ ସେଇଟା?
ଏଇଟା ଡିସାଇଡ ହେଲା my lord on 28/10 this honorable court directed it was calculated on the same day. It was 8/11/2024 and I paid on 13/11/2024.
କେତେବେଳେ ପଡିଗଲା କହିଲେ ଡେଟ୍ ଗୁଡା କହିଦେଲେ ଜଣା ପଡିଗଲା।
ଆଜ୍ଞା।
So he is saying, Mr. Roy, that the
I have no objection. I have no objection, Your Lordship.
So obviously I cannot, in fact, no,
ଆଜ୍ଞା
not received. Not received କଣ
ଦେଇଛି ସେ ରେଜିଷ୍ଟ୍ରି
ଆପଣଙ୍କର ଫାଷ୍ଟ ଅର୍ଡରଟା କାଇଣ୍ଡଲି ରେଫର again କୋଉଥିରେ ଡାଇରେକ୍ସନ ହେଲା 28/10
28/10 ରେ ଓଡ଼ିଆ 8/2024 ରେ the respondent number 2 objected and on the basis of that objection on 20/10/2024 this honorable court directed registry to re-verify and accordingly the registry re-verified and they have endorsed in the back of the order this is the amount payable and accordingly I have paid.
ସାର୍ ହେଇଛି ଆପଣ ଶିଳ୍ପ ପଚାରୁଥିଲେ now I have found out.
ଆଜ୍ଞା
Mr. hybrid board ଲେଖିବେ ହେଲା appearance ଡାକିଲି ତାପରେ ଇଏ ରୋହିତ ରଞ୍ଜନ ନାୟକ କଣ କହିଲେ ଆପଣ ନାଇଁ କରୁଛୁ ରୋହିତ ରଞ୍ଜନ ନାୟକ for the R1 R2
ନାଇଁ R1 sorry R1 R is the special execution officer.
R1 ହଉଛନ୍ତି ମିଷ୍ଟର ହର୍ଷବର୍ଦ୍ଧନ ସେଠୀ ପିକେ ମହାନ୍ତି এটা assignment পিকে মহাନ୍ତି so পিকে মহাନ୍ତି AC R2 ଆଗ R1 ହଉଛନ୍ତି ରୋହିତ ରଞ୍ଜନ ରେ it is submitted by the this senior panel counsel appearing for the appellate that pursuant to the order dated 28/10/2024 and 22/11/2024 by stamp report dated 8/11/2024 the applicable ad valorem to the ad valorem note fee has been valued by the stamp reporter by the ex-assistant registrar to be rupees 4934.25 The said valuation has been annexed to the note sheet maintained by the registrar. Note sheet of the case brief कर दें, है ना? Stamp reporting has been done again The report dated 8/11/2024 also indicates that the appeal is valued at rupees. The appeal is valued for payment of court fee. Sorry, the court fee determined for the appeal rupees 4934.25. From the said amount, rupees 333 already paid has been deducted. The rest of the amount being rupees 4601.25. Rupees 4601. ଆପଣ ଏଟା କେବେ ଡିପୋଜିଟ୍ କଲେ?
मतलब डेटा 13/11/2024 8/11 स्टाम्प रिपोर्टिंग कले
ତାପରେ 13/11 ସେଟା ଅର୍ଡର ହେଇନି ଆଉ
ना ये से पेमेंट रिसिप्ट ଦେଇଛନ୍ତି तापर ऑर्डर
पेमेंट रिसिप्ट कोर्ट रे फाइल ହେଲା
ना मो पाखरे अछि माने पेमेंट हेगला ई पेमेंट होला त मते रिसिप्ट
कोन दिन है केबे
ना कोर्ट मेमो कर देथिलिस
बुझछंती
आज्ञा आई हैव आल्सो अनदर मेमो विथ मी
जस्ट वन सेकंड अल्फा डीके The learned Senior Panel Council refers to memo dated 13/11/2024 to which the court fee payment receipt has been enclosed dated 13/11/2024 which is available in the case brief marked at flag G. The receipt, stop the receipt indicates that rupees the court fee amount of rupees 4802 has been paid. In view of the satisfaction of the determined, the appeal is in order. Delay nahi. Is there any delay?
No delay. Only there is a execution stay execution petition.
So notices have not been issued.
Notices issued, they appeared, but the execution letter filed, that's why execution of stay was later filed. Because without the execution stay execution petition, the number.
The Lawrence Senior Panel Council refers to the order dated with the code.
मतलब इम्प्रूव एग्जीक्यूशन केस
केबे नोटिस इशू होला अपील रे केबे कोर्ट नोटिस इशू करले
I guess 17/10/2022
the Lawrence Council for the Lawrence Senior Panel Council refers to the order dated 11/2023 wherein after appearance of the opposite party the appeal has been admitted and LCR has been called for. The matter shall be listed for admission. Yes, Mr. Ray.
Your Lordship, we have also filed our written notes of arguments on 10/4/22.
Notes rely करंतुनी that will create problem. Then solve it. You structure your argument on basis of your notes, but please refer to the pleadings available on record.
Yes. Your Lordship.
There is no scope for again reappraisal. What was the referral material? I mean, for the referral court. But you structure your argument on the basis of
yes. I appreciate it.
List for hearing or for admission as now?
Hearings
admission.
List for admission in the week commencing.
Lordship, next week.
LA is coming for hearing, so it has to be hearing. List for hearing in the week commencing. 24/4/26.
Yes, execution टा कौन से स्टेज
अपन एग्जीक्यूशन केबे फेल डेटा कहले पॉइंट कहले
एग्जीक्यूशन टा नंबर टा होचे आई नंबर 2023 एग्जीक्यूशन केस नंबर 2020
ए फाइल हैला
फाइलिंग डेट नंबर था केस नंबर टा अछि
आर्गुमेंट काय कर देले अपन जानछन कि
ना सेटा कॉपी भी देना छै हम
सर से फाइल कर एग्जीक्यूशन
फाइल करछन त अपन ता कॉपी मांगि देन से आउरी मोडे एग्जीक्यूशन आपण फाइल करछन्ती से कहउछन्ती जे आपण आत्मर को आपण एग्जीक्यूशन फाइल करछन्ती सेठी सेटा से कहउछन्ती सो सेठी पई आई वांटेड टू नो
No, no, I have to take instruction in that light. I don't have any instruction right now.
ओके ओके ठीक अछि आईएस 66 ऑफ 2023 था
आगे
ना 67 के तक
66
66 of 2023 the IA has been filed seeking a stay of execution stay further proceeding in the execution case number 3 of 2020 pending before the Court of Senior Civil Judge Khurda.
What I submit, Your Lordship, that IA has not been copied, not served with me, on me. That IA 66 by 23,
what I should submit it for you is that you have appeared in the appeal. Appeal has been admitted in your presence. So that can be ignored. Now this plea of not getting copy or not is obtuse.
Lordship, that...
I will find it. Let us assume there is no IA as such. Can the executor proceed after admission of the appeal?
In our absence, the notice was issued, Your Lordship, 17/10/2022. Order dated, Your Lordship, can you have a...
When you are removing virtual, everything is virtual. I just refer to that order. You should have heard. When I was discussing with, asking Mr. Kashyap, I have referred by which order it was admitted.
Would you copy it?
On that, the notice was issued to us.
Written that is copies में सब still I'll survey another copy to for example
अरे दे देने कोन असुविधा अछि that is in your interest ना पर एटा चलियो फेर आउतरे
ना ना
ना पारे कॉपी अछि
ना
only had done it senior panel counsel it is submitted that after the LWA was filed in the year 2000 was presented in the year 18/12/2019 before this court. Execution has been filed in the year 2020 2020.
Man.
Yeah. Copy of the IS shall be found on the learned counsel for the R1 as well as the learned AEC for R2. ଆପଣ ବାଜି ନା ଆପଣ ବି ପାଇନାହାନ୍ତି
ସବୁଡା
ଆପଣ କାହାକୁ ଦଉନାହାନ୍ତି ଆପଣ
ମୁଁ ଦେଇ ଦେଉଛି
R1 and R2
କାଲି ସୁଦ୍ଧା ଦେଇ ଦେବି
within 3 working days.
ଆଜ୍ଞା.
In the interim, it is directed that the further proceeding or execution case number so and so shall remain in abeyance in the next date of hearing.
Man, okay.
List of the direction सेटा से डेट आउट है लिस्ट इन वीक कमेंसिंग कर देगा तो
May I make a prayer?
Yes, please.
The TCR has already come. I'll put records. If I can take the trial court record photocopy touch. Photocopy touch.
Mr. Rai, आपन संगे राउची बदल को कोर्ट रेफर करछो. The learned counsel for the parties, the learned counsel for the petitioner as well as the counsel for the respondents have devoted to a soft copy of the trial court records. Trial court as well as referral court records as is available in the registry.
Oh, blessed.
Yes. Yes.
16.
Upon sir? Okay, so I'm so sorry. I thought that somebody is appearing. 16 में कहीं ना 16 none. Petitioner none. No, for the petitioner when the matter is called. The defect pointed by the SR shall be removed and complied with within 2 weeks of within 2 weeks to grant for the list for orders in the week commencing 6/4/2026. Registry shall intimate to the learned counsel for the today's order to the learned counsel for the petitioner.
17.
सेम ऑर्डर डेट से डेट से ऑर्डर सफे होबे से बेसी ही जीवो ठीक है सेम ऑर्डर 17 सेम ऑर्डर नॉन अपियर्स फर्दर यस यस मैडम
Item on behalf of SS Mahapatra, already purchased.
No, then request Mr. Mahapatra to file that memo. आपन को पावर अच्छी आपन को ना
M Sethi.
आइटम
आगे
आपन को पावर नहीं
ना
तांको कहंतु एप्लिकेशन जदि पावर नहीं आपण मेमो फाइल करंतु नहीं जहां कर पावर अछि तांको कहंतु मेमो देबे एबे दे परिबे पास ओवर कले
सर एपीपी ही जाइछन ना नेक्स्ट
अरे समस्ते माने 5 जन एपीपी एकत्र ही गले
आउ से 4 जन के
इन्फ्लुएंशियल चैम्बर अरे एपीपी पे बहुत चेष्टा करा जाउछि बहुत लोग चेष्टा करै नहीं पार नांती आपनकर 5 जन हे गले एपीपी
नहीं जणे छ आउ 4 जन ना
4 जन कहंतु आपनकर पावर नहीं नेवर टेक ए रिस्क ऑफ विथड्रॉइंग ए मैटर वेयर समबडी एल्स इज अपीयरिंग सो इट हैज consequence को दिन आनले हो पर दिन परदिन देबे ताले कोन आई एम नॉट पासिंग एनी ऑर्डर सिंपली परदिन अर्जन नहीं जाउछि एटा पर पोस्ट कर दियो 18टा पोस्ट कर देबे
ओ ब्लेस यू
yes and always be confident about your this practice procedural part is very important in day to day practice when I let me share one thing right I was appearing for the opposite party. One of the lawyers who is now having prolific practice, he is appearing today also. He told me you seek adjournment. So he was expecting that the court will ask him why you are seeking adjournment. So better the opposite party take adjournment. So upon adjournment. So I didn't say him anything. Neither did I take the adjournment. But सेटा अपन जानिया दरकार. It has a consequence. That's the point I was trying to tell you. Yes, next. इधर डिफेक्ट अच्छी सेम ऑर्डर कर दे. सेम नहीं परिवर्तन तो आगे. 16 19 नॉन एक्सेस टाइम दे देगा. Yes.
20.
So Mount was not. No, it was not good. Same order. Defective was the PH.
21.
I may plead your losses. Whereas in persons to
सीमेट्रल कहीं दिखला
restoration by dismiss for default
को वाला कहले
and say it mirrors that is order dated 24/3/2021 passed in WPC number 31386 of 2011.
Just once, I'll get that file. WPC रे केते ऑर्डर कहले 24/3/21
24/3
dismissed for yes since none is there to prosecute the case the writ petition stands dismissed for want of prosecution. Thereafter what happened? You have filed
I filed the
delay ही गला था
delay
कितने दिन delay
delay matters I filed it on that's 20 that is matters on 18/7/2023
18/7/23 माने 2 वर्ष नहीं गले
not aware about it. I have actually treated everything in the petition and by petition. So I was
you take a lenient view, Mr. Mishra?
My lord, I have nothing to say. I have been.
No. I mean, how can I justify the 12 happiest delay?
My lord.
Can you not pay some cost? Government को no.
80 वर्ष नाम आए
80 वर्ष रे आपण 2 वर्ष डिले करिवे फॉर रेस्टोरेशन ପାଇଁ
that is the
आपण फाइल करछन्ती माने that is within your knowledge
numerous that after what has happened in fact man respect
आपण ओरिजिनल काउंसिल की
I was not sure Mr. Rao
आपण ताकू कहबे ना this is against restoration has to the same council 96 Supreme Court I think or 97 that what is that builder or what is 97 Tamil Nadu State the city board you should bring the same counsel because Supreme Court has found upon this practice of engaging another counsel. It is almost like a review. They will not object, but why should you change the counsel? Or if he's available, you bring him, you appear, but let him at least restore the matter. That order I am not passing because that will be against you. You should not have changed the counsel once it will be dismissed. Then there is delay.
Very good.
For IA for conversion of delay, one counsel. CMPL, one counsel. It's a read petition, another counsel. That should not happen.
That read petition, there is some counsel.
It's almost like why you are changing the counsel because he is saying that because and now are you making allegation against the earlier counsel?
No, it is the issue.
You should never do that.
Yes.
You should never make a observation against your brother.
No, yes.
Because someday you may not appear, your case will be dismissed. Then you will approach Dr. Misra and say that Mr. Tripathi has
not.
Then you will write it. That should not.
No, I am not.
So, Abu Ukil kiye thile?
Mr. Rautray.
Associate kiye thile?
Se to
Senior ko na kon lekha hona ko. Tankaro instructing counsel kiye thile na?
So AGA was Das. He was conducting.
Bas. CA dismissal for non-prosecution nahi na tha. And every day you find many of them present in court.
Yes.
See not thile.
But
say yes, that's thile.
Yes, yes. That is
Certain PK se photo galani vel. Mr. Soros Sawal bhi chhad degani. SP Nath देखो you at least you request the counsel who was
originally
there
yes
in the but obviously not Mr. B. Rautray has passed away. I think B. Rautray was appearing in I think so anyway that may be the reason you do not know but you have to put the correct things to the court.
Yes, yes.
And it's a very old matter.
Yes, yes. It is an 11 matter, and
yes,
I am too old matters. It's 80 years and.
Mr. Subhash Chandra Acharya for the same appeal likhive hai na. Mr. Subhash Chandra Acharya for the petitioner. Mr. Prem Kumar Mahanti for the opposite party. Dr. Vinod Mishra for the number 3. देखो सीएमपीएल नोटिस है कि आपण प्रसार करछन आपण पाइछन को
यस
आपण पाइछन आइए नंबर 208 of 2023 along with CMPL लिख दे The IA has been filed for condonation of delay of 817 days in presenting the CMPL. After the writ application was dismissed by the coordinate bench by order dated 24/3/2021. Since the state bench is not available, the matter is listed before this bench as per determination. Stop. Apparently, after dismissal of the writ application for restoration, CMPL has been filed, but the petitioner has chosen to engage a separate set of counsel. In the fitness of the things, the learned counsel at present appearing shall ensure appearance of any of the counsel who were appearing when the matter was dismissed by the coordinate bench. List in Quebec has now.
Go to 1 week after.
List in the week commencing. So, Bari. 6/4/28/26. List for orders for that. Yes, next.
22.
ଏଟା ମେନସନ କରିଥିଲେ କି?
ନାଇଁ
କରିନାହାନ୍ତି। Non appears for the ଆସିଗଲେ sir. Sir, Bhavani Shankar Mishra for the Mr. Mishra. Mr. Mishra. Your name, sir?
E. Sharma.
Mr. A. Sharma.
Sharma. Sir, we'll file.
Sharma?
Sharmadi. SARMAD.
Sure. Sharmadi.
On behalf of yes, Mr. We'll file fresh notice, send fresh notice in the correct postal address.
Mr. A. Sarmadi on behalf of
B.S. Mishra.
B.S. Mishra for the petitioner.
Yes.
The learned counsel refers to the office. And submits that after notices were issued as directed by the order dated 15/9/2025, the notice issued in the limitation matter has been returned unserved with postal remark into court left. The petitioner has an adjournment to take notice in the present correct address for which the 2 weeks time is granted. Upon filing of the requisites in the present correct address, notices shall be issued afresh. Unutilized copy of the requisites shall be utilized. List after is at liberty to mention. Sharmadi.
SARMAD. Sharmadi.
Like Priyambada Mahanti Asbati Janti ke liye, Professor. SARMADI.
MAD. Yes.
SARMADI. Yes, next.
23 published.
My lords, I am for the opposite party.
Mr. Gaurav Das.
My lords.
Someone was present on behalf of the petitioner? Just now. From Mr. Bose's chamber. Can you file a memo? Today can you file? So I'm passing it over. After you file that memo, I'll pass that order, granting some further opportunity. Today I'll just grant further opportunity. Mr. Das?
It's 1 week after, my lords.
Exactly 1 week to Hyperibon. Item 23.
33.
Week commencing 33.
My lords.
But please file that memo. After that, I'm passing it over. You need not remain present. Because she says that no instructions. Obviously, I'll just you have to adjourn it.
My lords.
Yes, next.
34.
Yes. So Akshay Kumar Sahoo for the petitioner. Yes, Mr. Sahoo, not filed.
Filed में also.
Type copy filed.
Yes, ma'am.
When कितना filed? कितना filed?
5 दिन मैंने.
Again?
5 दिन निकल.
Oh, अच्छा. It is submitted referring to the office note regarding filing of corrected cost title, typed corrected cost title. It is submitted that on the cost title was filed on 5/3/2026. 2026.
Hello.
2026. 2026. Registry shall verify and proceed in the matter. List in the week commencing? Fresh matter na after notice?
Fresh matter.
List for fresh admission in the week commencing 13 ଆସିଲେ ହବ?
Yes, madam.
13/4/2026.
Another IML also.
ଆଇଏ କଣ ହବ କହିଲେ?
Condonation of delay, madam.
ଆଗ କରେକ୍ସନ ଟା ଆଲାଉ ହେଇଗଲା ତାପରେ
Okay.
ଆସୁ
Sorry, madam.
ତାହେଲେ ଆପଣ ଟିକେ ଜଲ୍ଦି କରୁନାହାନ୍ତି ତାଙ୍କର ଫ୍ରେଶ 4 କରିବେ
Yes, madam.
week commencing 6/4/2026.
Obligation. Great.
25
months. I'm appearing for the petitioner in this case. The previous occasion.
You are Mr. N.B. Rautray.
N. Behuria, my lord.
I'm sorry, N. Behuria.
On behalf of.
So N. Behuria.
On
Your full name is
Nityavrata Behuria.
Nityavrata Behuria on behalf of the Nityananda Behuria for the petitioner. You are Miss Rautray.
I'm Sarmisha Naik on behalf of Kiran Raut. Sarmisha Naik.
Miss S. Naik. You have power here. Mr. S. Naik on behalf of the opposite party. Yes.
So the
Mr.
previous.
C.K. Mahanti for AC. For
My lord, the substituted legal heirs of the decision 4 are not interested. ସେମାନେ ଆଦୌ ରେସ୍ପଣ୍ଡ କରୁନାହାନ୍ତି.
ଆପଣ ତାଙ୍କୁ କଣ୍ଟାକ୍ଟ କଲେ ରେଜିଷ୍ଟର୍ଡ ପୋଷ୍ଟ ପଠେଇଛନ୍ତି?
ମ୍ୟାଡାମ
Whenever you have to keep your records up to date. The method is that you send a registered post letter with AD, instructing, asking them to respond. They don't respond, so you can take that plea before the court. That despite intimating now it is speed post with the station. Registered post is no more available actually. First, you do that. Otherwise, they will take a plea that despite we entrusting the brief to a lawyer.
ଫୋନ ରେ କଣ୍ଟାକ୍ଟ କଲା ବେଳକୁ ସେ
Yes, may I clarify?
ଫୋନ ତ ଆପଣଙ୍କର ପ୍ରୋବ୍ଲେମ କଣ ନା ସେ they will just evade. That is how all the written part is important.
May I clarify one thing?
Please.
She is appearing for opposite party number 3 and original opposite party number 4 minutes.
Correct.
She died. Original.
I think you have heard her. She says the legal heirs of OP number 4 are not responding to this.
They won't also respond to that, because they are not interested.
But the problem is that there the petitioner cannot have any say. It is between the court and the OP4 whether they will respond. So now, and the lawyer is in a piquant situation because she says that they are not responding.
ସେମାନଙ୍କୁ fresh notice ଯାଇଥିଲା after the substitution marriage. So they have the liberty to engage any other counsel, not what their mother had engaged marriage.
Correct.
So
except you, they can engage anyone. But you cannot say that if they want to appear, they will not appear. So since they are substituted, they are by you.
Notice
so,
also.
So now, obviously, the lawyer on record, he will ask them.
Subsist କରିଗଲା
এটা ବୁଝିଗଲା
ଖାଲି ଏବେ 3 ପାଇଁ ଅଛି 4 ପାଇଁ ଚାହି ରହିଥିଲା
notice sufficient ହେଇଛି ନା
notice sufficient ହେଇଛି
by which order?
order dated 3/9/2025, order number 28. 3/9/25, order number 28.
3/9/25. Order number 28 question.
Order number 28.
Okay.
Para 3.
For ABC is still sufficient. Yes.
Now, may them be set ex parte on the matter may be posted for a final hearing. Regular as he
so it will be heard in their absence. It will be heard in their absence. So once it is anyone else who remains unserved.
No, man.
For ABC.
For ABC.
Once the coordinate bench has observed that it is sufficient, it remains sufficient.
For a D also, for D also it was held to be sufficient.
Para 5.
After the respondents being served as recorded by order dated 3/9/2025. Matter has been listed for admission with noting in the cause list for hearing and final disposal. The matter shall be listed for hearing in the week commencing 24/4/2026. Yes, sir.
27.
Just give me a moment.
I am the opposite party minor. Petition of astronaut being
Mr. R. Mahato for the petitioner. Ms. Dhar. Ms. Dipti Dhar for the opposite party.
Pardon my lord, opposite party number 1 is 8,000. Opposite party number 2 is 5,000. 13,000 ହେଇଥିଲା ସେ ହଉଛି 22 ମାସରେ ସେମାନେ କରିଥିଲେ ଗୋଟେ ହଉଛି ଏନାଉନ୍ସମେଣ୍ଟ ପାଇଁ ସେ 7 ମାସରେ କଣ 4,500 ଦଉଥିଲା ପୁଅ ପଢୁଛି ଯୋଉ ଇଏ କହିଲେ ଇଷ୍ଟ କୋଷ୍ଟ ରେଲୱେରେ ଚାକିରି କରୁଛନ୍ତି ଆଉ ସେ ପିଲାଟି ପାଠ ପଢୁଛି ଘର ପରେ
ଆପଣ ସେଟା ତ ମାନେ ସେଟା ଆପଣ ସେଇ କୋର୍ଟକୁ ଆପ୍ରୋଚ କରିବାକୁ ପଡିବ
ସେ ଅର୍ଡର କରିଛନ୍ତି ଅର୍ଡର ଦେଇଛନ୍ତି ଯେ 8,000 ହଉଛି ଦିଆହବ ପିଟିସନ ନମ୍ବର 1 ପିଟିସନ ନମ୍ବର 2 ହଉଛି 5,000 ସେ ଅର୍ଡର କରିଛନ୍ତି ଆମର ପୁଣି ଏରିୟର ପଇସା ସବୁ ଅଛି
ଏରିୟର ଏକ୍ଜିକ୍ୟୁସନ କରିବେ ନା
କିନ୍ତୁ ଆମକୁ ଏତିକି ଅର୍ଡର କରିଛନ୍ତି
ଆପଣଙ୍କର ଯେତିକି ଅର୍ଡର ହେଇଛି ଆପଣଙ୍କର ପ୍ରଥମେ ଥିଲା କେତେ
ଆମର 4,500
That was in a bad case.
4,500 ପିଟିସନ ନମ୍ବର 2 କୁ 1,500 ଆଉ ପିଟିସନ ନମ୍ବର 1 କୁ 3,000 4,500 ହେଇଥିଲା ସେଟା ହଉଛି 22 ମାସ
1,500 ସେଟା ତାପରେ ମଡିଫାଇ କେତେ ହେଲା
ମଡିଫାଇ ହେଲା ପିଟିସନ ନମ୍ବର 1 କୁ 8,000 ପିଟିସନ ନମ୍ବର 2 କୁ 5,000
ଆପଣ 8,500 ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
ଆଜ୍ଞା
ଆପଣ ଏଭିଡେନ୍ସ କଣ ଦେଇଥିଲେ ଟ୍ରାଏଲ କୋର୍ଟରେ ଦେଖାନ୍ତୁ ଆପଣଙ୍କ ପିଟିସନ ଦେଖାନ୍ତୁ ଆଉ ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଦେଖାନ୍ତୁ ଆପଣ 8,000 5,000 କୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
ଆଜ୍ଞା ଯେହେତୁ ମୁଁ କଣ୍ଟିନ୍ୟୁଅସଲି ମେଣ୍ଟେନାନ୍ସ ଦେଇ ଆସୁଛି
ତାମାନେ ଆପଣ କିଛି ଚ୍ୟାଲେଞ୍ଜ ଆପଣ 8,000 5,000 ଏନହାନ୍ସମେଣ୍ଟ ଚାହୁଁଛନ୍ତି ଆଉ ଗୋଟେ ଫାଇଲ କରୁଛନ୍ତି ନା ତାହେଲେ ଆପଣ କାହିଁକି ଆପଣ why you are opening your argument when you started I thought that you are thinking then let him open his brief yes
my lord earlier in a MAT case which was being preferred by the wife under section 18 and 20 of the Hindu Adoption and Maintenance Act.
You take your seat and listen to him.
In the said MAT case, the learned judge family court Bhubaneswar has passed an order wherein maintenance has been awarded for the wife 3,000 and for the son 1,500.
You come back again. This application is dated. This application was filed.
It was arising out of a MAT case, my lord.
Which one?
The present order, which I am challenging.
Under which provision?
This order was under the provision of 127 of CRPC.
Correct. 127 of enhancement.
For enhancement.
So the question, kindly appreciate the question. 125 CRPC application was filed when?
125 has never been filed.
125 has never been filed?
No.
So the maintenance was awarded by which?
The maintenance was awarded under section 18 and 22 of Hindu Adoption and Maintenance Act in a MAT case 495 of 2007.
495 is application under section 18 of the.
Yes, my lord. When there is a separate provision for enhancement.
Now, in 18, what is the provision?
Section 25.
Section 25. Now suppose a wrong provision has been quoted. What is the law on that? By quoting a wrong provision.
It is the discretion of the court, man.
No, not discretion. There is no discretion.
Allowed when
The law is well settled. The law is well settled by merely quoting a wrong provision.
a separate provision is already available.
Mr. Mahato, you have to listen to the question, then you can understand.
I beg pardon, man.
If you know the question, you tell me what I want to. What is the proposition I am asking you? There is no discretion for the court regarding the settled proposition of law. If a wrong provision is quoted, whether by quoting the wrong correct provision, is it your case that the court loses its power, lack of jurisdiction? Then it's a different thing. For example, High Court. I do not have power to entertain a 125 petition. I start entertaining a 125 petition. Before me, I pass an order in section 18 of the Maintenance Act. So for both 125 and 18, I do not have jurisdiction. At the court of, as the court of first instance, I have power in 227, appellate power in CRPC, supervisory power in 227, to certain extent 226 also. But is it your case that if the petition would have been filed under 125 CRPC or 25 in CRPC, now the order in 18 was passed by the court, enhancement is filed in 127 before the said court.
Same court.
So then it squarely comes within that provision. The evolution of jurisprudence.
Not by the same court.
Same jurisdiction ही पारे. Same court माने मुझे जो identical.
এটা আগে সিভিল জজ সিনিয়র ডিভিশন ভুবনেশ্বর পাস করতে
হ্যাঁ তারপরে এটা
ফ্যামিলি কোর্ট পাস করছেন
এটা ফ্যামিলি কোর্ট কি
ফ্যামিলি কোর্ট ভুবনেশ্বর
সেটা তো রাজনীতি প্রসেস নেই করে সেটা every matter has to be considered by the one court.
No, I am only placing my lord because it is the point of jurisdiction that when a MAT case has been heard by a senior civil judge invoking the jurisdiction of a civil court. After a 127, CRPC has been preferred by the wife.
127 is
when a separate provision is there under the said act.
So you look at Rajneesh versus Neha.
The lordship may allow me for some time.
No, right now I will allow definitely. But I must tell you that you are arguing and you have followed your senior in arguing in pertinent points. That is a very good thing. $128 देखो just read it aloud because I have handed over. I am also trying to make some effort to study along with you so that you get also some inputs from me and maybe I'll be inspired by you or you'll be inspiring. I will be inspiring you. Just read it aloud because I don't have a copy.
To overcome the issue
guideline
issue of overlapping jurisdiction.
Correct.
To overcome the issue of overlapping jurisdiction and avoid conflicting orders being passed in different proceedings, it has become necessary to issue direction in this regard so that there is uniformity in the practice followed by the family court, district court, magistrate court throughout the country. We direct that where successive claims for maintenance are made by a party under different statutes, the court would consider an adjustment or set-off of the amount awarded in the previous proceedings while determining whether any further amount is to be awarded in the subsequent proceeding.
They did further.
It is made mandatory for the applicant to disclose the previous proceeding and the orders passed therein in the subsequent proceeding. If the order passed in the previous proceedings requires any modification or variation, it would be required to be done in the same proceeding.
So they have talked about the overlapping jurisdiction also. After Rajneesh versus Neha, this point cannot be, has to be answered that yes, the court has jurisdiction.
But my lord, in the
filed, suppose, I don't know whether,
last point.
in जो order ta
This order was passed. This order was passed on dated 15/10/2022.
So Rajneesh versus Neha 4/11/2020. It is after Rajneesh versus Neha. That is how now this is being entertained by family court. Otherwise, it is a magisterial power. Even domestic violence is magistrate.
Yes, my lord.
125 is magistrate.
Yes, my lord.
After this, because I think you should have marked that it is actually 142 guideline. Because if you are filing, suppose an award is made before 24 by family court.
Family.
In fact, many cases, he is the senior most judge of the district, family judge. Then say 25. 25 is also modification, 25(3) enhancement.
Yes, ma'am.
That amount is to be taken note of while giving an award in 125. I hope you understand what I am saying.
Then that has to be disclosed. That has to be disclosed in the said petition.
Correct. Can the magistrate modify the order of family court?
No.
That is the thing. So that is how consciously Supreme Court has now, it has become a norm, almost a norm. Everywhere maintenance applications are filed and taken up by the family court judge.
But in domestic violence act cases, the petitions were filed before the.
It has to be because domestic violence act specifies it. 125 CRPC now 144 BNSS specifies it. It is a magistrate. It is family court has, but after this direction under one, because they say that we are issuing this direction under 142 of the Constitution of India. Just before that issue of overlapping years. So they have converged all this proceeding to one, and that order is dated November 4/11/2020. So strictly speaking, your argument is correct. It has to be there. Because you are saying that once the order is passed under Section 18 of the Maintenance Act, Guardianship of Maintenance,
That Hindu Adoption and
Maintenance Act, then it should be only by the self-same court for modification in 25.
Yes.
But in the meanwhile, it has come post 4/11/2020 versus Neha. I think that court is, we are saying, civil just senior division.
Yes, ma'am.
He cannot take up the matters into a family court also. He cannot.
Yes, ma'am.
So that is how the higher court is taking. But
that thing was not been taken note while.
As far as facts are concerned.
My lord, but that thing was not been taken note by the judge family court while passing this order.
Which thing I could not follow you?
The judgment that Rajneesh versus Neha, that proposition was not been taken note.
Which proposition?
That overlapping portion.
No, that's not necessary.
Another thing, my lord.
Even in criminal law, where mens rea is there, ignorantia juris is non-exquisite. The principle is, I give a slap to someone. Then I say that I do not know that giving a slap is an offense.
Another 25.
So now once it is 142, then kindly read this. Whether he will take or not, that the court has clarified it. That is very interesting.
The Lordship may allow me some time to.
No, I will. Since you are prepared and you are arguing with some definite preparation and direction. copy of this judgment be communicated by the Secretary General of this court to the registrars of all high courts, who would in turn circulate it to the all district courts in the states. It shall be displayed on the website of all district courts, family courts, courts of judicial magistrate for awareness and implementation. There is a direction for implementation also. I mean, they have done it with a purpose. I was sitting with Justice Vishwanath Ratha. So one maintenance matter he dealt with, and he discussed me with this, that there is no point that there is no aspect which has this decision has not touched. Only thing that something is that is affidavits, disclosure affidavits. When subsequent, when I was sitting with another division bench, the view is that by opening an affidavit, whether you can, the general discretion is curtailed, because 25 doesn't contemplate, 25 says or 24 says discretion of the court. But when you bring in an affidavit, that is not part there in the statute. And this part definitely, para 127, just as we read 128, we deem it appropriate to pass the following directions in exercise of our powers under Article 142 of the Constitution of India. That is not the land, actually. This has to be read with all the statutes. And they have said that it will be sent to every court, displayed in the website for awareness, and shall be implemented. So that, suppose he doesn't referring to Justice versus Neha and exercising jurisdiction, that cannot be, now it can't be reopened now. And regarding quantum, you have anything to say, because she has to respond to that.
Yes,
question of law, she need not.
My lord, I have challenged the said order, my lord.
No.
Because when the petitioner is paying the maintenance and continue paying the maintenance, my lord,
No.
the early pursuant to the order.
I asked to her, I thought that she is asking. In fact, I asked this question to her. I thought that it is her petition. Then what was your WS before the trial court? How you have said, disclose that, how much you are paying? So that kindly show that.
It was an ex parte order, my lord.
This is item 27.
The original order was the ex parte judgment, my lord.
So enhancement rate.
Enhancement rate.
What was your stand? Because when you are saying that now that perhaps that's the best point you have argued, that since it was an order under 18, instead of exercising jurisdiction 25, the court has exercised jurisdiction in 127. That's the question of law. But regarding the determination of quantum of alimony,
that was only taken note by the salary certificate which was been obtained by her under article.
So then you have to dispute that salary certificate. Now
no, that was not been disputed.
So then what argument you can make? If a salary certificate is taken note of, and if it is largely the guideline is 25%, what is the salary certificate?
That was not
amount. What is the amount indicated in the salary certificate?
39,905.
39,905 then. So the calculation is correct.
Then not.
They may be unhappy. They may be unhappy.
2022.
Again?
In the year 2022.
22. So they may be unhappy, or the amount as she is saying now, though she has not challenged it. She says that the amount is not adequate. As you have heard, that the son is prosecuting MCA. In today's costly world, whether 8,000, 5,000 is adequate. That is her. But anyway, I am not taking. So if the salary certificate, just the improved judgment, place it where they have dealt with.
Para 6, my lord.
Para 6, page.
Page 12.
First, look at the material relied upon. Go to the last page. Page 14. PW1.
PW1.
Wife.
Yes, my lord.
RW1 is
husband
for you, for whom you are paying.
Yes, sir.
So obviously witnesses were on the dock. They have been examined and cross-examined.
Yes, sir.
Then list of the exhibits, mark exhibit 1.
Salary particulars of the opposite party for the month of December 2017 on the RTI.
Okay.
And the salary particulars for the year to
September 2022.
Yes.
The order is 15th October 2022.
Yes, ma'am.
So then September 2022 is relevant. Now, is there anything? Now you have to examine, is there anything which will help you? If it is not help you, you should not argue that point. I don't know. Actually, whether by examination or cross-examination, have you been able to dislodge the claim for enhancement? Or you have found out anything? That you have to examine by going through the statements. That much is left.
Only for that, Lordship, I am praying for time.
Well, I understand. I have assured you that after hearing you, I must grant you time. Because whenever, in fact, after hearing for 1.5 hours, I realized that the case is not making any headway. Because when I start hearing, I think that it will make some headway. But after even after 1 hour or 1 hour, I realized that the argument once initiated is not carried further. So obviously, I'll grant you time. At least you have carried further your argument. But emphatic note argument arambha hobo, but kiss pare that fizzles out. तापर डिस्कशन हेले तार किछि नाही थोडु खाली चालीला सेटा को नेकी घंटे 1.5 घंटा 2 घंटा भी हे गला गोटे केस रे basically that is actually the court is not giving time. The court is persuaded to believe that as if something is achieved, but nothing is achieved that time. But at least in your case you have made an effort, achieved something. Okay. सेटा आपनकर एबे सेटा आपन जदि चाहउचंती सेटा एकटी टेक अप हे परिबनी. Or you are simply saying that you are satisfied with no interferences to be called for.
ଆମର ହଉଛି ସେ ରେଲୱେରେ ଚାକିରି କରୁଛନ୍ତି ରେଲୱେ ଇଷ୍ଟ କୋଷ୍ଟରେ
ଠିକ ଅଛି ସେଟା ଆପଣ ତାଙ୍କ ପିଟିସନ ରେ ଏଟା କହିବେ କେମିତି ଆପଣ ଯଦି ଏନହାନ୍ସମେଣ୍ଟ ଚାହୁଁଛନ୍ତି ତାହେଲେ ଆପଣ ଯାହା କରିବା କଥା
କୋର୍ଟ ଅର୍ଡର କଲେ
correct madam. Now in this appeal in his revision application you are supporting the judgment or not supporting the judgment. That's I am putting the question in a different जो judgment से challenge करूचंती आपण जजमेंट रे सैटिस्फाइड तो सपोर्ट करूचंती ना आपण करूचंती
सपोर्ट करूचंती
तो ठीक अछि लीव इट देयर अधिया काहे कि तको पर आदमी करूचंती यूटेसी डाल डिक्टेट द heard Mr. Appearance lecture given. Order 15/10/2022 passed by the learned judge, Family Court, Dash Roman 2, Bhubaneswar. One more thing, Mr. Mahato, have you examined the judgment, looking at whether you have taken that plea of instead of 25, why the court is proceeding in 127? Have you taken that plea?
No, Lordship, I have not taken the judgment properly. Only for that I am.
No. Upon judgment, what upon challenge kruchanti, jota pays upon annex question annexure 1 re.
Okay.
Have you taken the plea before that court? That you have not addressed. Just go through that and tell me. Okay. It is submitted. The learned counsel petitioner was had at length. Apparently the order dated 15/10/2022 was passed by the learned judge Family Court in CMA number 139 of 2016. The said CMA was filed by the wife in the marriage in about 39 years and minor son from the wedlock, born from the wedlock, then is it about 50 years. seeking enhancement of monthly maintenance directed earlier. In MAT case number 495 of 2007, directing payment of rupees 3,000 to the wife in the marriage and rupees 1,500 to the child per month. The order in the MAT number 495 of 2007 was passed by the Civil Judge Senior Division, Bhubaneswar. Para. There is a difference actually. Most like the lawyer has also missed it.
Yeah.
There who has filed, he has not, he has missed it. So in fact, the court did not have an occasion to know. ଆପଣ ସେଟା ପ୍ଲେନଟାଫ କି ଅର୍ଡରଟା ଫାଇଲ କରିଛନ୍ତି କି ସିନିୟର ଡିଭିଜନ କ ଅର୍ଡରଟା କି ପ୍ଲେନ ସେଥିରେ ଯୋଉଟା ଫାଇଲ ହେଇଥିଲା ଫାଇଲ କରିଛନ୍ତି?
I have the copy, my lord. If lordship
ନାଇଁ ଏଥିରେ ନାହିଁ ଯଦି ତାଙ୍କ ପାଖରେ ନଥିବ ନା. I should not.
within the, by tomorrow I will file, my lord.
So anyway, ଆପଣ commission ଟା ଅଛି, but I want just to see the date and all that. It has the lawyer judge family court doesn't know, the lawyer did not know. So I mean the counsel who was appearing for the husband also did not know. He ଜାଣିନାହାନ୍ତି ଏଇଟା କିଛି ବି ଲେଖା ହେଇନି. And since the designation is civil judge senior division, MAT case, that way most likely everyone has thought ki seta. It is submitted hard order counsel for the petitioner at length. The allotted counsel for the petitioner raises a question of law. Stop. It is submitted that the earlier MAT case number 495 of 2007, which was allowed by 12.8.2010, was an ex parte judgment. Stop. It is submitted that the petition, the said application, the said petition rather. The said petition was filed under section 18, read with section 20 into bracket 2 of Hindu Adoption and Maintenance Act, 1956. Seeking a direction for payment of maintenance, monthly maintenance at the rate of 6,000 for the wife and rupees 3,000 for the child. It is submitted that the Adoption and Maintenance Act. Section 25 of the Hindu Adoption and Maintenance Act, 1956 is the appropriate provision for seeking enhancement of the amount awarded. while disposing of the while allowing the MAT case, the learned civil judge had directed for payment of maintenance rate of 3,000 to the wife in the marriage and rupees 1,500 to the husband in the marriage. It is submitted that the learned judge family court dash Roman 2 capital 2 could not have passed order under section 127 of the CRPC for enhancement of the amount. In response to the said submission, on being the learned counsel was asked whether quoting of a wrong provision would affect the jurisdiction of the court, that is learned judge family court to pass an order. It is fairly submitted that it would not affect the order. It would not affect the jurisdiction to pass the order for enhancement. But when the original order was passed, not passed under section 125 of CRPC, the application for enhancement could not have been filed under section 127 of CRPC. It was brought to the notice of the learned counsel for the petitioner that the judgment rendered in Rajneesh versus Neha colon into bracket 2021 bracket closed to SCC 324 decided on 4/11 the Honorable Supreme Court have issued guidelines regarding issue of overlapping jurisdiction, that is jurisdiction into bracket small s exercised by various courts under various provisions such as section 125 of CRPC and Domestic Violence Act, in which the applications are usually made before the magistrate. Sections 24 and 25 of Hindu Marriage Act read with the substance, for which the jurisdiction is exercised by the family judge, by the family court, not family judge, family court or civil judge senior division. Jodi nahi?
Jodi nahi, it is civil judge senior.
The family judge, the learned judge family court or civil judge senior division, as the case may be. Stuff further, jurisdiction under section 18 and 25 of the Hindu Adoption and Maintenance Act. Then earlier used to be exercised by the 2007 କଣ ଭୁବନେଶ୍ୱର ଥିଲେ ଥିଲା ତ ଫ୍ୟାମିଲି କୋର୍ଟ
ସେତେବେଳେ ଏସବୁ ଜିନିଷ ଗୁଡା ତ ସିଭିଲ ସିନିୟର ଡିଭିଜନ ପାଖରେ
କିନ୍ତୁ ଫ୍ୟାମିଲି କୋର୍ଟ ଥାଇକି ସେଠି ଯାଉଥିଲା।
ହଁ 2012 ପରେ ଫ୍ୟାମିଲି କୋର୍ଟ କୁ ସବୁ ଜିନିଷ ଆସିଲା।
କଣ ଲେଖିଲା सिविल जज सीनियर डिवीजन पर to avoid conflicting and multiplicity of orders by several courts, which at times causes hardship for both to a claim for maintenance, that is the person who is seeking maintenance and person who is giving maintenance. The usual practice after directions issued by the Hon'Ble Supreme Court in Rajneesh versus Neha is that all such claims for maintenance are being entertained by the learned judge family court. Regarding the quantum of maintenance which has been enhanced, the learned counsel for the petitioner has adjournment to other arguments. So, para. Ms. Hara, learned counsel for the opposite party, wife in the marriage as well as the child who has now become a young adult, submits that the judgment, the order passed by the learned court is just and proper and did not be interfered with. List for further hearing in the list on the condition Mr. Mahato?
2 weeks.
Mr. Barik Mundu? The week commencing 6/4/2026. Thank you. Interim order shall continue till the next stage of your life. अब जेपर्यंत आपनको ऑर्डर अच्छी कोर्ट पचारू नांती ते विषय बिल्कुल आपण किछि किए करंतु टेक्निकली से ऑर्डर रे ए प्रॉब्लम ता अछि I mean we are taking hypothetical view because the court has jurisdiction, but obviously how can the court exercise 127 when there is no 125? Yes.
29 my lord.
आपल्यावर इथला मॅटरटा से मेमो कोडा कोडा ओडे 23 मेमो लिख दे अच्छा ठीक है ताछड़ा अर्जन कर दियो 30 ना हेची तो अर्जन हेची ना 30
29 my lord.
एक्सरा कितना नंबर आइटम 23 रे ऑर्डर लिखंतु Mr. Amit Prasad Bose for the petitioner, Mr. Gaurav Das for the opposite party. The learned counsel for the petitioner has adjournment to obtain up-to-date instructions from list in the week commencing 30 दिन कहले ना 30 दिन 2026. Mr. Mahapatra?
Let's see.
Mr. Gyanranjan Mahapatra for the petitioner.
It's actually power nahi.
ठीक है, ऑन बिहाफ ऑफ मिस्टर जे बारिक अछंती जे बारिक अछंती मझिरे
आगे
मिस्टर ऑन बिहाफ ऑफ जे बारिक लॉर्ड इंस्ट्रक्टिंग काउंसिल फॉर द पिटिशनर लॉर्ड इंस्ट्रक्टिंग काउंसिल ऑन रिकॉर्ड फॉर द पिटिशनर यस मिस्टर दिव्यज्योति साहू
जयंत कुमार
मिस्टर जयंत कुमार पाड़ी मिस्टर जेके पाड़ी ऑन बिहाफ ऑफ Miss Mukherjee, what is Miss Chatterjee?
Rituparna Chatterjee.
Miss Paddy and Miss Chatterjee on behalf of Mr. Bose for the opposite party. Yes, Mr. Mahapatra?
Let's see, can it be taken up next week, my lord?
Okay.
Well, in this case,
I mean, beyond this matter, I'll not start, open the brief so that it will remain partly unheard.
My lord, in last occasion, order dated 7/17/2026.
Yes.
Given the last chance for as for the adjournment, due to the interim order, they have taken the. We are also filed with the stay, vacation of stay.
That is happening.
So
In all your matters, you are taking adjournment, you are interning, interim order is there. So there, the stand of the law is correct. Upon a case adjournment, no,
my lord categorically said that there is a last chance. That order can see, my lord. 17/2026.
WPC 1210 to नाम को फाइल दे
1210
ठीक है.
Order dated 17/2026.
Mr. Padhi, Learned Counsel, refers to the order dated 7/2/2026, particularly paragraph 3, and submits that this court has already directed that interim order shall not be extended. Stop. And the adjournment is sought for on behalf of the Learned Counsel for the petitioner. The matter stands adjourned to be listed in the week commencing 13/4/2026. Yes.
That's it.
Item 30. Say Kohinothante. I don't think you would have sought for extension of. You must understand, many things are silently said is enough. He would not have extension of interim order. Yes, Mr. Bhanti.
Lord, here a person who has retired since May 2021 has not got his provisional pension. In the original order, this Hon'Ble Court directed his representation to be considered, and twice contempt petition has been filed. Till today, no provisional pension has been granted in her favor. And she retired as a
court directed for consideration of representation or directed for payment?
Directed for consideration of representation. Because
what is your instruction?
So last letter which was
no, you get it done.
2024.
Because you see, must understand, if she is not getting anything, at least she should be reconciled with the fact that she is not given. Don't keep her hanging.
I have forwarded the letter to the.
If you want to give her, give her. If you do not want to give her, at least pass the order so that she can challenge.
Provisional pension, my lord, a person who retired as a joint director, School and Mass Education Department.
For provisional pension not given because pendency of.
No, nothing. Okay. Nothing, my lord. Simply the administrative.
Very strange.
Very strange. You lords may kindly see. There is see.
No, it is content. I'm not going to the.
That is what I said.
It's a coincidence. I spent today reading the pension rules. I had some work there. Since yesterday I started reading, I could not sustain the tiring day. Today morning again I started reading.
There is no proceeding.
Mr. Sethi, this is for you because he is a veteran in this branch. The pension rule itself very specifically gives how it is to be prepared, when it is to be prepared, when to be sent, everything. This is the only rule where everything is prescribed.
Calendar wise.
And you will get it in that. There is separate handbook for government servants. Old books, little bit. Now I don't know whether it is being published.
You lordship have rightly referred to CS pension rule.
Pension is there.
There, everything is there.
Is also there.
Yes, ma'am.
Another publication is there. The pension rules for
Kolingo House.
And
yes. Yes. So only.
So he as a young counsel, he must.
Yes,
gradually step in, grow and.
Yes.
Content, obviously, I don't have anything to say on merits.
Here, the only thing which pinches is a person is not getting provisional pension for no proceeding, nothing, promoted rather just before his her retirement. But still, my lord, because of lack of pay fixation done at their end, everything.
But this happened. Of course, provisional pension is given.
That should have been.
But final pension, it takes time.
That's a different issue. That is
happening.
On the date of retirement, this entitlement given. Now it is 5 years going to be completed in 2026 May. We are in 2026 and the order has been passed in 2022. Twice contempt petition and your lordship knows, my lord, how things are being. So your lordship.
Mr. Appearance Lichon. The Learned Counsel for the petitioner expresses concern regarding the situation that is obtaining in the present case. Comma, the petitioner has retired
since
working as a joint director in the Department of
School and Mass
Education
since 31st May
upon attaining
2021.
age of superannuation on 31st March
2021
31.05.2021. He is yet to receive provisional pension. He had approached earlier by filing WPC number 35928 of 2022, wherein direction was issued by the coordinate bench by order dated 23/12/2022. PC 12/22, disposing of the writ application, directing the authority to dispose of the representation, copy of which was annexed to the writ application, marked as Annexure 5, seeking seeking a sanction and release of provisional pension. Did I put a pension by a provisional pension by sanction and release of provisional pension, oblique pension,
and retirement benefits
and all other retirement dues.
Yes.
Thereafter, CUNTC number 5601 of 2023 was passed as the order directing disposal of the representation within 3 months was not complied with. The content application was disposed of at the stage of admission by order dated 12/9/2023 by a coordinate bench, extending the time to directing as well as extending the time for compliance up to 23/12/2022.
No, my lord. 1 month more time was granted for compliance of the original order dated 23/12.
By 1 month. Last what up to no, by 1 month. By further 1 month. From the date of order. From the date of order, that is 12/9/2023. In response, the learned council, the learned additional standing council submits that he is trying his best to obtain instruction and may be granted some further time. Further time is granted with observing that if the authorities want any other documents or papers which they seek, which is required for processing of the pension application,
provisional
pension oblique pension application for grant of the same, they shall ask the petitioner to provide, and the petitioner shall provide the same. Pendency of this present content application shall not be in any manner come in the way of the authorities to take a decision and pass appropriate order as directed. Apart from of the representation as directed by order dated in WPC.
At least
no, now at least because it is unusual that somebody not getting pension takes time.
Yes,
I understand.
Yes,
and for no reason.
Yes,
that I can assure you that it takes time, 10 years, 12 years.
Yes,
without any reason.
That is what I from my side says voluntarily. So unless provisional pension is paid, how I subsist.
20/4/2026. Sufficient time is given, Mr. Seth.
Yes, sir. By then,
person is desperate. He has retired. He is now 64,
Your Lordship.
65 rather.
65.
65 plus.
Recently underwent heart bypass, but still without money.
Your Lordship, when it so happens that
So if pension is sanctioned, he will be getting, he will not be getting the medical benefit. So it is better he gets treated till he gets the pension. Otherwise, he will disqualify himself to get any medical benefit.
Aye. So at least provisional the मिलते थे पहुंचता है ये बड़ा फायदा
I'll send the letter today.
Yes, yes, yes.
Oh,
31.
Possible talk to them.
Yes, sir.
In person,
I always
discuss
call
with
them
them.
and then I
Discuss with them that this cannot.
Your Lordship.
After notice matters, rest of the matters we cannot. Take up. Upon 31 to 34 upon date darkar.
My Lord, interim stay may continue.
Senator, I am not touching it. I am not passing any order.
Let it come 2 weeks after my Lord.
31 ta date करछे तू ताले date दे दियो.
Item 33.
We commencing 13 4.
Item 33.
Miss Swai, you are mentioning some matter.
Yes, my lord, item 40.
Sir,
Position matter, my lord.
just we are going to that page. 31 पर
33. 34.
32.
33.
33 date darkar.
My lord, yes, transfer petition filed by the wife. Stay nahi, the other they are proceeding in the family court, my lord. So the time was short for by the lord for the husband.
Other side तो नाहंती.
Short day.
अनेक सब तो आसी नाहंती है. से पूरे तो
Last भिसरे time नहीं
time नहीं थी. आज तो आसी नाहंती से.
हाँ तो next week आडू आसु.
Next week में नहीं करियो. Because next week जो matter अच्छी ताजे तो add होगा ना किसी लाभ भी नहीं. आनिले कौन अपन जो 80 टा matter आसीबो. आसी परिबो. I mean I am just giving you examples. But after a beyond a certain limit जाओ तो नहीं. अब बेले बेले 2 घंटा hearing वाला पर किसी ही पड़नी. तो सेटा भी ଗୋଟେ अच्छी factor. सब factor मिसे मासे हबो.
The interim order that I would know.
I understand. 33 date
become infructuous more automatically.
Possibly you mentioned in his presence. So that at least he will not complain that the order was passed behind my back. Order means adjournment date. We commence in 13 week. Yes. Item page 5, 35 to 40. Upon 40 को 34 no yes
मेंशन करली लास्ट ओकेजन रे भी एटा रीच करि पान मतलब
25 मैटर तक केमति रीच करिवो
शॉर्ट डेट
सर व्हेन वी आर स्टार्टिंग विथ 2010 मैटर अब 2025 मैटर तो सीरियली आसीबो तो देयर यू मे नॉट हैव एनी ग्रीवेंस
राइट सिधरे
डेट रेड करंतु 34 तक डेट करंतु अच्छा वी कमेंसिंग अपन गोटे काम करंतु अंकर मिस्टर राज रेनी को मैटर ता को 6 4 कर दियंतु ए मैटर टा को 13 4 कर दो अपन तो बहुत लाइक करछंती अपन ना कोन
हरप्रसाद पंडा
मिस्टर पंडा यू आर लाइक बाय द कोर्ट मास्टर अपन मैटर तळे अछि सीधा रे गेलेनी 6 4 जोडा आगु अछि त कोछन 13 4
एटा टिके पूर्वरु असके ना
एटा सेटा का 24 वर्ष एक्चुअली दैट इज अपन मार्क करलेनी एटा मेनी टाइम्स आई से समथिंग रीडिंग समथिंग 24 वर्ष मैटर को रखिले 13 रे 25 रखिले 6 रे सो सेटा जस्ट Yes, got the without much changes. Yes, next.
My lord, item may I
2010 matter Ms. Manti.
I may be pardon, my lord.
Yes.
My lord, I may be pardon, my lord. Item
yes, sir.
37, my lord. My lord, this matter, my lord, transfer application, my lord. Interim order is there, my lord. I pray
interim
next week.
सर इंट्री मॉडल कोऑर्डिनेट जोटा कंचन सेटा हम सब जगह वेकेट कर देबा की
आगे
तो आप 2020 मीटर लिस्ट होची आसुची दैट मच आई कैन टेल यू आगे आप चाहतो सुंदर नेक्स्ट वीक कोन तो सर मैं नेक्स्ट वीक रे लिस्ट को ऐड कर देले किसी बड़ कथा न हेई परिबो बट डज इट सॉल्व एनी पर्पस यू मस्ट अंडरस्टैंड दैट बाय एडिंग टू द लिस्ट डजंट हेल्प बिकॉज़ ऑलरेडी मैटर्स आर देयर 37 डेट कर कोन तो केबे
24
वी कमेंसिंग 24 मिस्टर सुंदर राय
माय लॉर्ड interim order to continue my lord
no interim order I am not touching interim order I am not passing any judicial order touching any interim order Looking at your anxiety, I'm just marking the matters for adjournment to a particular date. That much I am doing. And it is done in the computer, not by any order also. That saves time. Yes.
Item 35.
35, yes, madam.
I'm for the respondent.
You want a particular date ଚାହୁଁଛନ୍ତି adjournment କେବେକୁ ଆଣିଲେ ହବ ଆଜି take up ହେଇପାରିବନି. Don't expect the matter will be taken up.
Sorted.
ଦେଖନ୍ତୁ 35 କେବେ ହେଇପାରିବ 13/4. Yes.
36.
May I please your lordship?
Yes, please.
36.
36 mention କରୁଥିଲେ ଆପଣ
ଆଜ୍ଞା.
ଆଚ୍ଛା କରିଦିଅ 13/4. No, I'm not marking anything. Actually, this technique of simply passing a order and adjourning it takes a lot of time because this order has to be typed, signed, file has to be returned, then it can be posted, then it will go to the listing section, then posting. So when they are posting it, they are doing it instantly. So that is my understanding. That is how I'm not. In a way, it saves a lot of time. Yes, sir.
May I please your lordship? Item 40, my lord.
38 go there.
Okay.
Mention it.
Let them solve a copy, please. 36.
36, sorry?
Let them solve a copy.
Copy ପାଇନାହାନ୍ତି
No.
ସେଇଟା ମାଗିକି ନେଇଯିବେ ଆଉ କଣ କରିବା
Notice by guest.
ଆପଣଙ୍କ ଆଫ୍ଟର ନୋଟିସ୍ ମ୍ୟାଟରରେ ମୁଁ ଯଦି ଅର୍ଡର ଲେଖିବି ଆପଣ ବାହାର ଯାଇ ବହୁତ ହସିବେ ଆଫ୍ଟର ନୋଟିସ୍ ମ୍ୟାଟରରେ କହିଲେ କପି ସର୍ଭ କର
ଏବେ ମ୍ୟାଡାମ କପି ଦେଲେ ଭଲ
ସେଇଟା ଆପଣ ନେଇଯାଆନ୍ତୁ ନହେଲେ ଆଜିକାଲି ସଫ୍ଟ କପି ହେଲାଣି ଆପଣ ଡୋନେସନ ନେଇଯିବେ କଣ ଅଛି Items of running after a lawyer for serving counter, then finding a memo that he is not receiving copy. Those days are gone. By now, simply click of a button, it is solved. Item 38 lekhantu. The matter being in the list is mentioned by the learned counsel for the petitioner, Mr. Gaurav Das lekhibe. 38, Mr. Gaurav Das for the petitioner. Opposite party blank. Opposite party 38 ki achandi ki? Opposite party blank. Matter being in the list is mentioned by the learned counsel for the petitioner. He files memo of date which states the following. The memo shall be taken on record, scanned copy be updated. पानी सरी जाइए अपन पानी देना ठीक है the petitioner wife in the marriage before this court seeking transfer of the CP number 227 of 2025 Court of Learned Family Judge Kendrapada to the Court of Learned Family Judge Jajpur. The CP was filed by the opposite party husband in the marriage under section 13 into bracket English 1 bracket closed, then bracket Roman small I dash a, seeking dissolution of the marriage solemnized between the parties on 01.05/2016. Stop. In view of the memo filed, the petition stands disposed of. Copy of this order shall be forwarded to the Learned Judge Family Court Kendrapada to be kept in the records of civil proceeding number 227 of 2025. Yes, Ms. Swine. Item 40.
My lords, the mediation became unsuccessful. It was referred to the mediation. My lords, with your permission, may this case be referred to the Lok Adalat.
Unless you agree, then what is the point in sending you? In case of a failure of mediation, if both of you can work out, I can directly listing on Saturday also. But for that, it requires a lot of effort. You talk to your senior and talk to your learned colleague if something can be worked out with mediation. Usually, the difficult part is that in land acquisition matters, so because it involves financial implication, any official is reluctant to pass that order. They think that why even if it is 1 rupee, questions will be asked. If by Lok Adalat, if anything can be done, you discuss.
My lord.
Shall I mention Mr. Sethi that this can
Lok Adalat is good.
Mr. Anshuman Sethi, AC for the appellate. Miss, I've just forgotten your full name.
Sunshine Swai.
Miss Sunshine Swai, on behalf of AC Swai for the respondent. The learned counsel for the respondent, Miss Swai, refers to the mediation report receipt, which has been placed before this court, which is available on record at flag T. Apparently, the order dated 23/12/2025 passed by the learned apparently, the mediation report dated 22/12/2025 by C12/2025 indicates that the mediation could not proceed. The mediation could not achieve any result, and therefore the matter has been referred back to this court. The opening sentence लिखी, the matter being in the list was mentioned by the learned counsel for the respondent. Now, it is stated by the learned counsel for the respondent that an effort can be made for settling the matter in the Lok Adalat. For the said purpose, the learned additional standing counsel is also requested to make efforts. In case of the parties agreeing for settling the matter in Lok Adalat, the proposed settlement can also be worked out by the learned counsel for the parties, so that the matter can be referred to Lok Adalat. By what time?
Your Lordship, 14th, the Lok Adalat is there.
Aji 10 sir.
Your Lordship, I'll call up the.
Then the list are Aji 10 sir. Tale 13 re asu.
Yes.
The matter shall be listed for orders on 13/3/2026. Liberty to mention. Yes.
Grateful.
Okay. Ashubat Kusine.